At 901.
Yes, Mr. Dwivedi.
Well, but perhaps I was waiting in anticipation when Lordship would put a question, how much time would you take now? So, but I think I should conclude it within an hour and a half or maybe a little.
If you can try by 11:30 today, so that then we'll give Mr. Datar.
I'm
Now, what is the lineup? It's basically you, followed by that, Mr. Datar. 10 minutes for you. So the two major arguments now are by Mr. Dwivedi and Mr. Datar. By Jaideep Gupta. How long will Mr. Gupta take? Is it possible for all of you to wrap up by lunch today, so that, you know, if this side, Mr. Datar, about, and if what I was thinking was that maybe if Mr. Dwivedi concludes at 11:30, then we'll give Mr. Datar till lunch, so you'll get about an hour and a half, and then maybe an hour after lunch for everybody together. So by 3 o'clock, this side can get over, and then the solicitor and the attorney can start at 3 o'clock today. So we'll wrap up by 3 o'clock tomorrow on this side, and then we'll have one rejoinder from all of you. All of you can sit down together and see who will do the rejoinder. One rejoinder for 1 hour tomorrow, and we'll close tomorrow evening.
Not due respect, Lordship, but I would request Lordship not to ask us to combine together, because that never happens. Invariably, Lord, everyone wants to say his own kind of thing, which he has up his sleeve.
We are doing all other benches, all other CBs, we have had one rejoinder, and others may give a small note of a page or something. Perfect. So that there'll be one rejoinder. And if you feel that anything else has remained, one-page note that, well, these are the major points which we wanted to highlight to supplement what Mr. Dwivedi has argued. Because rejoinder really should be one.
Only one, the caveat. Look, concluding it tomorrow may perhaps not be possible. There are two reasons. A, the Lordships would find in all these judgments, the argument is this judgment was not cited, that judgment was not cited. Listen, we would not like to be accused of not citing everything. And number two, 9-judge combination sits rarely. If we cannot cite some judgment and lack of assistance results into something, that might, but will not repeat anything, will not be irrelevant. And my submissions would be other than what they have already argued, rather than dealing with.
And my lords, apart from attorney and solicitor, there are private parties also. I'm representing them.
After the attorney, but you're on supporting them.
Yes, ma'am.
So something
Whatever,
you can give us a
whatever is
one-page-
left, I'll cover.
just a one-page note or
I won't
something.
repeat.
The others after the attorney and the solicitor, a one-page note by all of you. Tell us what the points are which have been left out. which
I
you'd like
think
to-
other means he is the only one. Our team is smaller.
No.
We have filed a written submission. That's
Yesterday I was seeing Mr. Abhimanyu Bhandari also.
Attorney, followed by me and Mr. Agarwal, my lords.
So keep a one-page note ready so that we can then, we'll be time. Of course, we'll hear it. No difficult. It's a pleasure to hear all of you, but just keep a one-page note ready.
And my lord, I would curtail my submissions, my lord, but kindly give 10 minutes each to, my lord, the colleagues who have really prepared well. They wish to address your lordship. I would wish them to address your lordship.
Certainly.
Brilliant young people.
Also. Yes, Mr. Dwivedi.
Lord, kindly recall the question which Lordships had. Because that question, I must confess, has given me some sleepless night, therefore I need to elaborate on that.
Yes.
But the question which Lordships had posed was that intoxicating liquor contains various items on which regulations can be made, like manufacture, production, supply, distribution, transport, etc. So virtually everything with regard to intoxicating liquor. This is irrespective of whether it contains potable liquor or industrial alcohol. Apart from that, then Lordships felt that even entry 52 contains the same thing, and therefore there is a conflict and a clash. Now, if Lordship would kindly have entry 52 again for a moment.
Yes.
Does it contain the same thing? That's the issue. And is there a clash?
By
That's the issue.
interpretation, it has been held to contain the same thing.
No, I'll answer that. No? Is there a clash? That's the question eventually. Entry 52, list 1. Industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest. Now, whether we can read this word control so compendiously and expansively as to include everything that is contained in entry 8 note, that's the issue. Because if it does not, then there is no conflict. And this will also entail the question, Lord, whether industry here is so expansive as to cover sale, distribution, transport, etc. Trade and commerce. Will it include bird control? That's it, of industry. Now, Lord, when we compare the two entries, entry 8 list 2 and entry 52 list 1, there is a vast difference in the language. That's one aspect Lordship may note. Because lots of things would turn on the word control, whether they include whatever is included in entry 8 or not. That's the question. None of the cases, Lord, none of the cases which I had cited up till ITC come to this conclusion that the word control is as broad as what is included in entry 9. Supply, distribution, trade and commerce, everything, it's not there. There's a considerable unanimity from 1956 onwards till 2002. At least 7 constitution benches would say, if you have to see this expanse of this scope of this entry 52, you must see entry 52 is by itself not a field of legislation. It becomes alive only when a declaration is made with regard to an industry. Then that industry is transported from entry, perhaps 24 and comes to entry 52. So what is the source, I ask myself? The source of the power of the field is entry 24 exclusively. Lordship would recall that statement in Ishwari Kehta, Justice Krishna Iyer, Constitution will say, only from entry 24. So whatever is dragged out of 24, that comes to 52, nothing more. So there are 2 ways of looking at it. One, when we want to see the expanse of the word industry in control, then we must go back to the source, which is entry 24 list 2. Because whatever is contained therein can possibly come here. Entry 52 cannot drag more than what is there in the well or the source. And entry 24, Lord, has been analyzed in at least half a dozen cases. One was which I had cited in a very limited manner, but I just need to place that judgment and then that will answer Lordships. Now, Lord, question is this word industry in entry 24, what is the expanse of that? Because as Lordship has seen, all the cases are unanimous that word industry in entry 52 would mean the same thing as entry 24. There is a intricate and intimate link between the two, Lord, which cannot be snapped. Now, Lord, if word industry here is of limited expanse, then we can't expand the scope of entry 52 beyond industry in 24, entry 24. Now, let us see, Lord, the scope of entry.
Tikaramji says that industry industry covers 3 elements. One,
yes, widely,
raw
in a wider way, it covers 3.
Raw materials, manufacture or production,
Right.
and distribution.
Right.
It says that raw materials would not be comprehended within entry 52.
Because they're not part of industry.
Then second, they say
The end
manufacture or production would also not be covered unless it is a controlled industry. Once it is a controlled industry, they say manufacture or production will also be covered by entry 52. But they say that even in respect of a controlled industry, distribution of the products goes to entry 33. So in your favor, in case a industry is declared as a controlled industry, the distribution of the product goes to the concurrent list. In the concurrent list, unless there is a legislation by the center which prohibits the states from enacting
that
the law,
aspect, not little later.
the states are not.
That's the B part of my argument.
Therefore, for instance, you can certainly levy a fee in relation to distribution is concerned.
But the difficulty that is arising with due respect, if I can explain, is because we are trying to trace the word industry in all its expanse on its own. But what the case law from 56 onwards till date indicates is the word industry takes its color and scope and expanse and depth and breadth, whatever it is, not from entry 24. Now let us see what is there at the initial stage, what is there in entry 24 which can be taken over.
You know, if you go to Tikaramji again, which was what we read yesterday at volume 5, page 96.
I mean, let me kindly bear this fact in mind. In Tikaramji, the issue was of entry 33, not for the product of notified industry. Tikaramji is different. Tikaramji was a case of entry 33 because there was an entry containing foodstuff over there. And therefore it became it fell within entry 33 list 3. Not because it was product of notified industry. Sugarcane was never regarded as product of notified industry. Your Lordship, may I have entry 33? For a moment. 33. This 3. Trade and commerce in and I'm sorry. (33A) relates to product of industry notified under IDR. B relates to foodstuff, and sugarcane was traced to foodstuff in Tikaramji. And therefore they said there is an express entry here for foodstuff, therefore it won't go to industry. So Tikaramji is being misunderstood with the due respects here, because Tikaramji is not a case of product of notified industry being regulated, but instead raw material of the industry, which is sugarcane. So when Tikaramji segregated the end product as well as raw material, it first went to entry 24. And therefore, what I am submitting with respect is kindly go to entry 24. And then let us carve out what is included in entry 24 in the state list. Because as I said, not source is entry 24. If the source doesn't contain something, then perhaps you can't expand the source by taking it over in entry 52. Now kindly have entry 24.
Your argument, basically, you've got the point that your argument, we'll have to hear the other side of that, is that this product relates to entry 8 of list 2.
Completely.
Right.
You don't have to go to entry
step 1. Once it relates to entry 8 of list 2, it does not fall in entry 24 of list 2. Point number 2. 3, if it doesn't fall under point number 3, the concept of industry in entry 24 is the same as entry 52, or rather entry 52 industry is the same as entry 24. So 4, since entry 24 is not applicable, likewise, therefore, entry 52 is not applicable.
Exactly. With due respect,
So,
I'm grateful. No, that's
and
what
your, that's really the 5 points which you have made. And
it's
really
also
speaking, the whole fulcrum of your submission depends on whether industrial alcohol is an intoxicating liquor within the meaning of entry 8.
exactly. And for that,
Because that's the first and foundational argument which you have
I'm
made.
extremely obliged. Not I had to work whole night on this, but lordships have really taken it.
So
I'm-
these are the 5 steps which you have built your whole argument on.
And this would be clear.
And you say that industrial alcohol is intoxicating liquor by saying that, well, you must bear in mind the past legislative practice, the provisions of the Government of India Act, entry 31, and how it was interpreted by the courts,
Exactly.
the 2 British acts, which Balsara said you must look at. And therefore, Balsara says, according to you, that industrial alcohol intoxicating liquor would include liquor fit for human consumption as well as denatured spirit. That was the broad Balsara.
Here, the lordship may add 2 more decisions
Just,
relating to
one more addition to that. Industries is basically a state subject.
State subject.
52 is bio of exception.
Now, Lord, here, lordship may very kindly add 2 more decisions, Lord, relating to denatured spirit and industrial alcohol, which were held to fall in, Lord, intoxicating liquor under entry 8. One is perhaps not the Southern Pharmaceuticals.
Because those, apart from Balsara?
Yes. Southern Pharmaceuticals. Southern Pharmaceuticals, PDF page, volume 5.
What is the citation?
1981, volume 4, SCC 391. The relevant paras are para 6, 12 to 14, and 17.
How many judges is Southern Pharmaceutical?
This is, I think, 3 judges.
I think just the AP Sen's judgment, right?
I'm sorry.
Is it just the AP Sen's judgment, I think?
No. I'm sure. Your Lordship is right. No, it is Justice Epicence.
That's the classical judgment on
That's the-
fee, tax and fee, I think.
Yes. That is a different judgment.
That's a different.
That's Hext
Not this,
Pharmaceuticals.
that's not this one. All right, that's Hex, you're right.
That's-
That is
That's
83
ADC, this is Southern, yes.
That's Hex one. But that judgment, Lordships may have a look into it, for with due respects. For this reason, not what was troubling Lord Justice Nagarotna was the notwithstanding clause. It has been beautifully explained in that judgment, because this clause was there in Section 100 Government of India Act, from where we have borrowed this.
So
So it has been beautifully
Southern-
explained there.
Southern Pharma also says that intoxicating liquor includes
Not that.
industrial alcohol. What is
There,
that?
a rectified spirit was being used for manufacture of medicinal and toilet preparations. So they said it comes within entry 8, intoxicating liquor. Then the next is perhaps what? Indian mica and mechanite. It's a constitution bench judgment. 1971, volume 2 SCC 236.
PDF page 5. PDF page 5.
It's a PDF,
Page 5, volume 5.
page 5, volume 5.
The earlier judgment, where do we get it in volume 5?
1985, 18. PDF page 1985.
PDF page 1985.
Volume
And in the second judgment, which is the relevant para?
Yes. Paras.
And just give us the PDF.
I'll give the relevant paras. Para 3 and 12.
Page.
page 7,
PDF page 7,
5A.
volume 5A.
5A. Okay.
Mark. So these two judgments, Lord, further elaborate on this and accept the content.
Quickly, those two judgments. Let's have a look at those two judgments,
Well,
because one is just for CB, so
yes.
You can see the CB here.
let's see first, and then we just quickly
1971.
glance through the next one. First one was volume, second is 5A. 5A hai, so we'll go to page 1985 for a moment. Para 6 and 12 to 14, right?
Can you have para 3, Lord?
Of Justice Sen's judgment, right?
Justice Sen's judgment. Hegde's judgment. Justice Hegde's judgment. This is 71, Lord. You've gone back as far
All
back
right.
as 71.
Well, just give us a minute. I'll just go to volume 5A. 5A, no?
5A.
5A page. What's the page at page volume?
Volume 5?
A.
A.
PDF page 5.
Volume 5A, PDF page 5.
Yes.
Paragraph 3, Lord. Page 7 of the PDF. Lord. The appellant is a consumer of denatured spirit. It purchased denatured spirit from the wholesalers or the manufacturers for the purposes of manufacturing mechanite. The Bihar and Odisha Excise Act 1915 came into force on January 19 and January 1916. In pursuance of the provisions of that act, the impugned rule was framed by the Board of Revenue for levying license fee. The fee for the license to possess denatured spirit in 1919 was only ₹2 per annum, irrespective of the quantity of the possession of a person. This rate continued to be in force till 1937. At this stage, it may be remembered that under the subsection 143 of the Government of India Act 1935, the provinces were authorized to continue to levy tax, duties, cesses, or fees which were being lawfully levied prior to the commencement of that act. under the 1935 Act, as under our present constitution, the power to levy duties on alcoholic liquor fit for human consumption was allotted to the provincial legislature. Whereas the power to levy duty on alcoholic liquor not fit for human consumption was allocated to central legislature. Denatured spirit, though, and alcoholic liquor not fit for human consumption. The power to levy duty on the same was and is given to the central legislature. But the same being intoxicating liquor, the provincial legislature under the 1935 Act and at present the state legislature has power to levy fee. The power of any legislature to levy fee is conditioned by the fact that it must be by and large quid pro quo. So they not relegated the matter back to the court that please look into it because whether it is a fee or not. And this issue was of license fee on denatured spirit, possession of denatured spirit. Rest is not a rest is on fee. What is fee and so on and so forth.
So they remitted it really on the whole question turned on fee.
Reasonableness. And whether it will be a tax or a fee. So kindly have para 12 then.
There's really no. If they say it is an intoxicating liquor.
Kindly have para 14.
In fact, they say therefore the duty, meaning thereby probably excise duty,
Excise duty.
will be levied by the center. But it's an intoxicating liquor, and therefore a fee can be levied by the state under 66.
And then in 12 said, let us see whether the impugned levy can be justified under as fee or not. That's it. That is para-
This sentence is,
Sorry.
go ahead, please.
So, Mr. Dwivedi, you see here the product that is being discussed in the judgment is denatured. That means it is made unfit for human consumption,
Unfit.
right?
Right.
So thereafter, although it starts off, the entire liquid, it starts off as an alcohol after molasses, it is made unfit for human consumption
By adding some.
by adding something. So that is fit only for industrial use. And we are looking at a kind of product which is alcohol and capable of human use. Is that what you are trying to?
Quite right. And I'm at the same time trying to indicate is not if denatured spirit, which is made unfit for human consumption, can be regarded by the Constitution bench as intoxicating liquor, then what to say of the rectified spirit, which is, it's not a denatured spirit, and we can't say it is as incapable of being consumed or not. Because not all that is needed in rectified spirit is that you put mineralized water into it and dilute the strength of the liquor from 90% to 35%, and it's drinkable. In fact, all over the country liquor is this only. There's nothing else. Country liquor is nothing but rectified spirit diluted by this demineralized water. So portability does not mean not having as it is. Portability, therefore, my submission would always mean that it must have some intoxicating element which may cause or is capable of causing intoxication. So it will include both, something which can be had as it is, plus what is capable of causing intoxication.
And those who imbibe neat, would they be called purist?
Lord, by that definition, Lord, I do call myself a purist, Lord. Because I prefer single malts, Lord, therefore they can't be had. Lord, if to give an example, Lord, it's very interesting. I went to Edinburgh, Lord, that's a mecca of single malt. So I am a lover of single malt. So I went to a bar. There I wanted to put ice cube into my single malt, which they served me. So the bartender got annoyed. He said, "You can't have this. I mean, it's a single malt. You got to have it neat. You can't mix it with water, soda, or cube. After all, ice cube is nothing but water." So he got annoyed. That's the first time I came to know a single malt is had like that. And there's a separate glass for it. It's not the normal whiskey glass. That's beside the point. I just do. Number the other is the Southern Pharma.
In relation to a human being.
In relation to, obviously.
So
That-
therefore, it is alcohol fit for human consumption. Will it involve then industrial alcohol? Because industrial alcohol per se is not fit for human consumption.
No, as we pointed out yesterday, Lord, the legislative history indicated that both denatured spirit as well as potable alcohol were part of intoxicating liquor. All the excise acts, the Intoxicating Liquor Act of 1910 of Britain, the certain acts, Volstead Act of US, they all regarded the industrial alcohol as part of intoxicating liquor. In fact, the Spirit Act of 1870 of of England was they showed the awareness about denatured spirit. It is specifically mentioned as part of spirit. The local acts definitely mentioned it as intoxicating liquor includes denatured spirit. Because the reason is, Lord, as a Lordship saw in those definitions, all liquids containing alcohol are part of intoxicating liquor. That was the definition in all those acts.
Intoxicating liquor really, in your submissions, would include liquor which is fit for human consumption and liquor which is not fit for human consumption. Right? Because the intoxicating liquor in that sense in your submission is a broader concept, which is not confined only to liquor which is fit for human consumption. The only difference which arises is in regard to the taxing power.
Taxing power.
If it is alcohol fit for human consumption, the center has no control. If it is if it is alcohol which is for human consumption,
Then it goes under
then it
51.
goes to the states.
51 list.
If it is unfit for human consumption, the center can levy a duty,
One,
right, under entry 84.
84.
But the power of the state, once it falls under entry 8, the power of the state to levy a fee is preserved by entry 66.
To regulate.
To regulate.
Regulatory fee can be imposed.
Whether in a given set of circumstance, a regulatory fee or something is is an independent determination.
Quite. That's an independent issue. Now, Lord, there is an interesting question which I had posed yesterday
Can you
slightly.
see Southern Farmer since we were on
Yes.
it, so we close this part now.
Yes.
Volume 5, page 1985. तो सेन साहब ने लिखा है
This is a judgment of 3 judges, Lord. Justice AP Sen judgment. And this is that deals with the industrial alcohol. ये तो पहले आ जाए. Judgment would make more sense if a lordship would. This judgment would make more sense if a lordship would allow me for a moment to place the entry 51 list 2. List 2. This would make more sense. Therefore, I was going to that. Entry 51 says, duties of excise on following goods manufactured or produced in the state and countervailing duties at the same or lower rate on similar goods manufactured or produced elsewhere in India. Now, A is alcoholic liquor for human consumption, which means not what it means is there is an alcohol which is not for human consumption. That's one thing. Now, my apparent question is not if alcoholic liquor for human consumption is regulated under entry 8, where is the alcoholic liquor not for human consumption regulated? There is no entry anywhere. The word industrial alcohol is not used in the constitution.
That point you made yesterday.
So it can come under industry as such. Under,
No,
can
that's what
come
I
under
would,
entry
that's-
54 industry,
that is answered.
subject to
Let's,
entry.
let's assume at the moment it does, but I'll answer that.
Yes.
Now, alcoholic liquors for human consumption, there is no parallel entry with regard to alcoholic liquor not for human consumption. In any of the lists, if they were using this phraseology, then it was very convenient for them to have used the same phraseology more or less for regulating industrial alcohol. If the framers had that in mind. Then the more important part is, note, if you Lordship would see, the excluding part, the last part. But not including medicinal and toilet preparations containing alcohol. Now, this part is excluded from the state jurisdiction only for the purposes of levy of excise duty. Because here also, there is no legislative entry in any of the lists regulating the distribution, trade, commerce, etc., and medicinal toilet preparation.
But both are in.
So it was very convenient to have put a legislative entry in this regard also. And that is why Lord Southern Pharmaceutical says that these medicines and toilet preparations containing alcohol come in entry 8, following Lord Balsara. All liquids containing alcohol. Medicines containing alcohol, Lordship would recall, Lord, during time of prohibition, cup syrup was a very, very go-to kind of an object for most of the people addicted. They used to have cup syrups in large quantities and consume whatever alcohol was there in that. So medicinal toilet preparations containing alcohol also fall in entry 8. And this is what Balsara said, and this is what Southern Pharmaceutical follows.
Point in that little
Yes.
extract from Southern Pharmaceutical, which says that.
Yes. Can you have para 6 more? It's very clear. This is a case where the spirit was being used for manufacture of drugs, medicinal products. And para 4 contains the challenge. But this is not the case of idea. 6. Enactment of Medicinal Toilet Preparations Excise Duties Act 55 by Parliament under entry 84, list 1 of the 7th schedule to the Constitution, or the framing of the Medicinal Toilet Preparations Excise Duties Rules 1956 by the central government in exercise of their rule-making power under Section 19 of the Act for purposes of the duties of excise on medicinal and toilet preparations containing alcohol, etc., do not prevent the state legislature from making a law under entry 8, list 2 of the 7th schedule to the Constitution with respect to intoxicating liquors, or a law under 51, list 2 for levying excise duty on alcoholic requirements for human consumption. In order to appreciate the contention regarding the applicability of the doctrine of occupied field, it is necessary to examine the scheme of both the acts.
Yes, this is also clear.
Then 8. The legislative history of this central act, I'll over that, but I'm sorry, I will be. Para. Good.
Irrelevant.
I would pray, Lord, kindly have it from para 12, 13, and 14. It is the charging section which gives the true index to the real character of a tax. The nature of the machinery by which the tax is to be assessed is not of assistance, except insofar as it will throw light on the general character of the tax. The charging section in Section 3 of the Central Act clearly shows that it does not seek to levy a duty of excise on alcoholic liquor for human consumption falling under 51 list 2 of the 7th schedule, but to levy a duty of excise on medicinal and toilet preparations containing alcohol, etc. This is the central rule. Last line, not last two lines, but there can be little doubt that the Central Act must in its substance be attributed to entry 84 list 1. In determining whether the enactment is a legislation with respect to a given power, what is relevant is not the consequence of the enactment on the subject matter, or whether it affects it, or whether it is in pith and substance. It is a law upon the subject matter in question. The central and the state legislatures operate in two different and distinct fields. The central rules to some extent trench upon the field reserved to the state legislature, but that is merely incidental to the main purpose, that is to the levy of duties of excise on medicinal and toilet preparations containing alcohol. Similarly, some of the impugned provisions may be almost similar to some of the provisions in the central rules, but that does not imply that the state legislature has no competence to enact the provision. It is sufficient to say on the first ground that the impugned legislation is confined to intoxicating liquor, that is to ensure proper utilization of rectified spirit in the manufacture of medicinal and toilet preparations, and therefore within the power of the state legislature under entry 8 list 2. It further seeks to regulate the manufacture of bona fide medicinal preparations and prevent misuse of rectified spirit in the manufacture of spurious medicinal and toilet preparations containing alcohol capable of being used as ordinary alcoholic beverages. It was suggested that the provisions are identical with the provisions contained in central rules, and in particular Rule 45(1), and therefore the legislation is in the occupied field. The answer is that the enumeration of intoxicating liquor in entry 8 list 2 confers exclusive power to the state to legislate in respect of medicinal and toilet preparations containing alcohol. But perhaps that answers Lord Justice Lord Nagratta's query. The exclusive power cannot be taken over under 2024. That's what we are expanding this argument. The exclusive power of the state under entry 8 or entry 25 list 2 is exclusive power. Is carved out of the general power of industry, entry 24. And therefore, that exclusive power cannot be at all taken by the center by making a declaration under IDR.
In other words, Mr. Dwivedi, your argument really would be this, that the bifurcation in regard to the legislative competence of the center on the one hand and the states on this subject is in respect of the levy of the duties of excise. Right? So what the centralist does is that the power to levy duties of excise on all goods produced or manufactured in India excludes alcohol fit for human consumption. That is a central list, entry 84. Alcohol, which is duty of excise on alcohol, which is fit for human consumption, which is taken out of entry 84 of list 1, is given to the states under entry 51 of list 1, of list 2, right? So this is the bifurcation in regard to the taxing power. Now, insofar as the substantive power to regulate is concerned,
there is no division.
There is no division at all. The only reference to the substantive power to legislate on intoxicating liquor is in entry 8. And entry 8, therefore, would cover the broad gamut, whether it is fit for human consumption or unfit for human consumption.
All liquids containing alcohol.
But even though you have the power to regulate it under entry 8, state cannot levy the duty of excise on alcohol which is not fit for human.
There is another factor. Not supposing I levy a fee. I levy a fee which is very harsh and excessive. Then lordships can turn around because regulatory fee is to recover the cost of regulation. But then if it is very high and very harsh, then it becomes a levy which is generally to churn out revenue. which is then becomes a tax rather than a fee?
Those are independent challenges.
That's the question. And that's an independent question. We're not concerned. Just as in synthetics too, they came to a finding that the levy imposed there was went fee on rectified spirit or a denatured spirit. And their lordships felt and came to the conclusion that the levy is excessive. So they said it's a tax. And if it is a tax, then they said that there is no power in the state list to tax the rectified spirit or denatured spirit, except in 51, which is excise duty. There's no other power. Taxing power has to be expressly given. So they are separate. So therefore, they said there is no power enabling the legislature to tax rectified spirit or denatured spirit. Therefore, that levy is bad because it's a tax. So that question in that decision note turns really on this.
And there is no substantive provision in list 1, either dealing with alcohol which is fit for human consumption or unfit for human consumption. Surprisingly, not surprisingly, but list 1 is advisedly silent in regard to that. There is no specific provision in list 1, except in regard to taxing. And therefore, taxation is a completely different thing.
So therefore, the question is, when they were dividing the object into two for the purposes of tax, were they oblivious of the fact that there are two separate categories? The fact is, they realized that the intoxicating liquor containing alcohol is included. All liquors containing alcohol are included in entry 8, intoxicating.
And look at the beauty of the constitutional division. Just as a aside, entry 24 of list 2 covers all industries.
All industries.
Right? So the entire gamut of industry is governed by the states under entry 24 of list 2, except whatever is declared to be a controlled industry under entry 52. Yet, though the state has full regulatory power on industry, you can't impose a duty of excise on any goods produced by your industry. The power to impose the duty of excise is given only to the center.
There was a reason for it. Not I went into that issue. Why is this? The reason is primarily because India had become independent. Now it required funds, huge funds, and excise was the biggest revenue churner at that point.
They wanted to give it to the center.
That they wanted to go to the center.
To also have uniformity. Uniformity with regard to rate of excise.
Right.
But there is no substantive provision in list 1 dealing with either alcohol which is fit for human consumption or
even medicinal toilet preparations containing alcohol.
The only reference we have is to intoxicating liquor in entry.
Only. There is another interesting factor. (17) of the southern pharmaceuticals. That's also interesting because they again fall back on Balsara. But Lordship, just make a note of it. That is reliance placed on Balsara.
So Balsara is approved again.
Yes.
Slightly different.
Again, the issue is all liquids containing alcohol.
Sweep all.
But there is a little more interesting factor which I may bring out to Lordship's appreciation. And that may further clarify the position. Lord, let us
We are at 11:30. We've understood now your point and you've made it very succinct.
I'm grateful, Lord. Lordships
Can
have
now
not.
call upon Mr. Datta.
But then since Lordship, as Solicitor said, Lordships are sitting in high judgment, which is not a recurring kind of a thing.
Why don't you do this, Mr.
There is something important which I want to point out.
One more thing which we would like you to do is that obviously because you are arguing in the flow of the submissions, we ask a question, then you cite a judgment.
Right.
Just on maybe one page or 2 pages, just in chronological order,
It's there in my written submission,
There's no
in the
difference.
chronological
Then of
order.
course we'll have
But this
PhD.
aspect is something which becomes a thought-provoking idea comes not when we are researching, thinking over it, then it comes up.
All right, now
This is what I wanted
tell
to
us
submit.
what more.
Yeah.
What more?
Not apart from the fact that the industrial this intoxicating liquor has been expansively read because of the legislative history and the legal sense. Now, if your Lordship would recall the Lordship's query yesterday, is there a conflict between entry 52 list 1 and entry 8 or entry 25? And my answer is there is no conflict.
According to you, once it falls under entry 8, it
Or
can't
25.
go into entry 24.
It
And
can't
if it doesn't go into entry 24, it can't go into entry.
The reason being, Lord, the source is 24. The power under 52 is not like entry 97, residuary power, where everything can be dragged in. But source is there for entry 24, that for entry 52, that is entry 24 only. So it can't go beyond entry 24. If entry 24 does not contain something, then it cannot be contained in entry 52. And that is the reason why ITC struck down the central law. Calcutta Gas struck down the central law, IDR. That is the reason why McDowell strikes down. That was a case where the declaration was made with regard to even potable liquor.
Really speaking, the universe of industry is contained in entry 24.
Wow.
What entry 52 does is, it carves out a portion of what would otherwise fall in entry 24 by allowing Parliament to make a declaration.
Wow.
So what is left in 52 is, or rather what is taken in 52 is that limited area where Parliament makes a declaration. Anything which is not covered by a declaration by Parliament does not come into 52 but comes into 24.
That's one aspect, but I'm grateful. The other aspect is not what
But before Parliament makes a declaration, it must otherwise fall under 24. If it doesn't fall under 24, what's Parliament making a declaration under 52 about?
The difference being entry 97 doesn't have a source, but entry 52 has a source and therefore is limited, unlike entry 97. So we can't drag every industry which is not specified somewhere in any of the lists, put it into
So the
entry
concept
52.
of industries in 52 and 24 is coextensive. It completely covers the same field, except that once a declaration is made by Parliament, it's exclusive then.
It
That's all.
abstracts from that.
It abstracts from it.
Then the
That is-
question is, how much of entry 24 is in entry 8? How much of entry 24 is taken away
I'm grateful.
into a
This is the
Separate-
question. This is the question answered in Calcutta Gas as well as McDowell, that when we look at entry 24, then what we notice is that it cannot include other industries which are there in this exclusive state jurisdiction. So entry 24 is exclusive state jurisdiction. It cannot fall in entry 24. Likewise, entry 25, gas and gas work, which is exclusive state jurisdiction, cannot fall in entry 24. Likewise, not raw material, which is covered by entry 17, 27, 26, 27, which is the exclusive state jurisdiction, cannot fall in entry 24. That is the reason for not segregating industry from raw material and
Actually, now take it today now, for instance, on a lighter vein, but it's a very important constitutional issue. Sports, entertainment, amusement, it's an industry today,
industry.
right? Sports is not just amateur now, it's an industry.
Quite right.
So because sports, if you see sports, entertainments and amusements falls in entry 33 of list 2.
And then kindly see 21 fisheries. That's
Fisheries.
also industry.
34, classical industry, betting and gambling.
Betting and gambling.
So once there are specific items here, Calcutta Gas tells us that you can't even put it in the general entry.
Exactly. I'm grateful, but and if we follow that entry 52 will include all the industries, then perhaps Lord, this will be the difficulty. So many entries would be rendered absolutely ocious. But Calcutta Gas and McDowell, the classical cases which answer this confusion. It is true, word industry is wider, but these are the industries that are abstracted out of the general word industry because they are special. So special carves out an exception from the general, and therefore they are exclusive. Once lordships have held not it is exclusive in the exclusive state list as an exclusive entry, then it is plenary. Otherwise, the consequence would be we would be making all these entries, not fisheries, sports, betting and gambling, gas and gas work, intoxicating liquor, subject to entry 52, which in fact it is not.
in the context of intoxicating liquor, in that context, or in the context of the world of alcohol, so to say, is there something beyond intoxicating liquor, or is that the most and the highest comprehensive term?
That's what I indicated. Lordship saw the legislative history of the local acts, and there's of at least 1915, 1910, 1909 vintage, which definition was borrowed in the Government of India Act 35, intoxicating liquor. So these are the local acts which use the phrase intoxicating liquor, meaning liquor consisting of alcohol, all liquids consisting of alcohol.
Now, Mr. Dwedi, keep your powder dry for the rejoinder, otherwise,
But I have to conclude this part. If Lordship would just permit me to, there's a couple of pages left in the written submission, which will conclude. No, I would start from page 25 of my written submissions. No? He is important. बस वही बचा फिर सिंथेटिक्स पढ़
So, people are concerned, so attorney is not here, so we don't want to. Mr. Attorney,
No, they just attorney.
Is that?
we caught by surprise, we don't know that we are. Mr. Attorney,
Your Lordship,
we'll of course hear you in your turn, but just as a matter of curiosity, are you going to be arguing that entry 8 will only cover potable liquor and not industrial alcohol?
yes, yes. Only potable liquor.
So you will be arguing that Balsara is wrong, therefore.
To a limited extent, Balsara, in fact, proceeds in an entirely different issue. Balsara doesn't address this question directly. Balsara is in the context of import of potable liquor, possession of potable liquor.
All right. Thank you, Mr. Attorney.
Right.
What is the content of, we have to give them.
Turns on entry, whether what do we mean by intoxicating liquor?
Yes.
And but with all due respect, as some lordships have always emphasized, a general entry using general phraseology must be interpreted in the widest possible manner. And why should we not pay the same respect to this entry? I ask myself. It's also entitled to the same expansive interpretation.
It is only to contain intoxication.
Let's, anything now, Mr. Dwivedi, you wanted us
Yes,
to
Lord.
see
Can you
page
come to page
25?
25?
All right,
Just
Let's
only
run-
2 pages, not that.
certainly. There's
Volume 1A.
1A.
It states, it's not the page 25, PDF.
D, right?
D, Lordship, I just have a look at it. Not there, I have compared it with the word intoxicating drinks. And the contention is that if it was only a beverage form, then they would have used the word intoxicating drink instead of intoxicating liquor. So there's a difference. In every which way we may look at it, not it traces it to the local acts. The state's power, B1 then.
Yes.
I'm not sure.
This is your alternative argument.
Yes.
Volume 1A, written submission, page 25.
1A.
But because synthetics shut the states off. And through a lethal observation, I would say, most lethal observation, paragraph 84, 85. They said even NT 33 does not give the power because IDR, once it is there, it covers the whole field. There's nothing left for the state. Which perhaps not, I'd show it's not correct. The state's power to regulate industrial alcohol can also be traced to entry 33, list 3. I'm sorry. The state's power to regulate industrial alcohol can also be traced to entry 33, list 3. Entry 52, list 1, as shown above, also includes manufacture and not trade and commerce, supply and distribution of products of notified industry under entry 52, list 1, IDR Act. IDR Act notified fermentation industry. Therefore, manufacturing in such industry would go to entry 52, list 1, but not trade and commerce and supply and distribution, which go to entry 33, list 3. The power of state to regulate industrial alcohol survives. However, it would be subject to Article 254 as the said entry is in concurrent list. IDR Act contains Section 18G, which purports to regulate industrial alcohol only by means of a notified legislative order, which is a control order. Section 18G is only traceable to entry 33 of list 3. The central government has not issued any order to regulate industrial alcohol as per Section 18G. Therefore, there cannot be a case of conflict or occupied field. The field is unoccupied and the state's power to legislate, to regulate industrial alcohol is untrammeled and complete. This position has been made clear in the following decisions. But these decisions, Lordship, may just note two, my lord, which include all these judgments, and I'll give the paragraphs too. That will solve, my lord, make your Lordship's task easier. The judgments are, my lord, Belson versus State of Bihar, 1999, 9 SCC, 620. This is volume 5, PDF page 2069, 69. Now the relevant paras are paragraph 116 to 118, 168 to 171. This is a constitutional bench judgment. Lord.
What does it hold?
It holds not that there has to be a notified order to create a real conflict. If there is no notified order under section 18G, then there is no issue of conflict. Conflict has to be actual and not possible conflict in future. So the IDR Act does not, perhaps by its own presence, and section 18G by its own presence does not take away state's jurisdiction until and unless then the other is not ITC. Lordships had seen some of it yesterday. 2002, volume 9 SCC 232, volume 5, PDF page 1597.
Yes. And what para are you referring to in
Yes,
this?
paras are para 84 to 88.
Yes.
Then, Lord, and this is all those cases I have narrated here, but the conflict has to be in fact an existing and not in realm of possibilities. Next page, Lord, page 21. These are the cases which do that. Lord. They also mentioned 2002 and 99. Therefore, despite declaration under IDR Act 51, in the absence of any order being issued under section 18G, I'm sorry. In the absence of any order being issued under section 18G, the state's jurisdiction in relation to industrial alcohol, IAM is a short form of it, I had indicated earlier, cannot cease merely on denaturation of rectified spirit, making it unfit for human consumption. Because even denatured spirit is a product of.
And finally, you say that mines and
Notified.
mineral cases are different because the product is not covered in the concurrent list.
The other thing is not that in the end, not there is one judgment which we need to really not emphasize on is the VAM organics. 2004, volume 1 SCC 225.
Volume 5, PDF page
Okay.
118. 5A, right? Page 118.
But this judgment is important because relying upon synthetics too.
118.
Minor.
Volume 5, 5A, sorry.
Relying on synthetics too, this VAM Organics says
118, sorry, 118. I clicked 18.
the relevant paras are not para 22 to 28, 29, 43, 29 to 43. And this says clearly, not that synthetics has brought down curtains for the state to regulate industrial alcohol. And therefore the jurisdiction ceases. So instead of reading it, I'll just make it clear. That's the sum and substance of that judgment. So far as synthetics case is concerned, my friend would be dealing with that judgment, the correctness of it in detail. But there are two things which I want to point out only in this regard, and then I conclude my arguments. Synthetics, not first 67 pages perhaps is the arguments noted. Then in the paragraph 67 and 68, there are two important reasons given for coming to the conclusion that denatured spirit or the rectified spirit is not included in the word intoxicating liquor. And one important reason is that they have adopted ISI standards for the drinkable alcohol, intoxicating drinks. So ISI standard prescribes 42% for whiskey, 30% for vodka, and so on and so forth. Therefore, it is a kind of a alcohol which can be consumed as it is in the actual form and not when it mixed with something. So if it is mixed with something, then industrial alcohol will remain industrial alcohol. But if it can be had as it is, then the word intoxicating liquor is confined to that. That's one aspect which is really damaging. The other aspect is, and there is no reason given over here, no rationality. They all of a sudden rely upon, they ignore the lordships have ignored the, I mean, I say with respect, the legislative history, the meaning of the term intoxicating liquor, which would have come to entry 31, list 2 of the Government of India Act. They have completely ignored that. They haven't gone into the legislative history, legislative sense, but they say popular sense.
Let them, we'll come back to it.
But the second is even more damaging. It says the judges were not aware of the use of industrial alcohol at that point of time when Balsara was there. But that's the logic given. And therefore they included it in intoxicating liquor. But somehow the other I felt not.
Well, we'll see. They'll be relying heavily on it.
Well, I'm extremely grateful for the kind consideration.
Arguments are intoxicated.
Now at least I can have my neat. Not in the afternoon, that's not.
What are your preferences, Mr. Datar?
If I made a colorful chart also to show how it is made. But now, since I've got an hour and little bit to go, but basically we have to decide whether synthetics of 1990 deserves to be overruled. And we have to answer those 6 questions which are raised in the referral order. Fortunately for us, the Law Commission went into this aspect in 1998. And they said that synthetics has created a lot of confusion, exact word they use. And they recommend that the IDR Act be amended and entry 26 be changed. That was done with retrospective effect from 1953 or 56. So the amendment to the IDR Act completely changes the complexion of the whole situation. So first submission is correctness of synthetics, then the Law Commission report and the amendment, that's the second one. Thirdly, I will just supplement on entry 8, the importance of entry 8, and the question of what is the interplay of Article 246, 246.3, and one should not forget 254.1, not 254.2, 254.1. Secondly, on intoxicating liquor, Lords, I just heard the Attorney General say that on intoxicating liquor, the union wants to take the stand that it will not include industrial alcohol or denatured spirit. But in synthetics and chemicals, they expressly took the stand that the word intoxicating liquor includes both. And what I'll do, my lord, before going to that, I'll just, with your lordship's permission, just give, because, sorry. And they expressly say Balsara should not be reversed after 38 years. That's the stand they took in synthetics. Para 41. So, my lord, in case they choose to argue, I may be in reply relying on an article on executive estoppel as to how the executive cannot change its stand. Once it has taken a position, it is an executive estoppel, provided that will be in the reply, not now. There's a wonderful article by Francis Bennion in Public Law on the nature of executive estoppel, and he discusses Pepper versus Hart and so on. Now, my lord, before your lordship, with the lordship's kind permission, I'll just give a brief idea, because before we understand the legal aspect, we'll have to understand how the industry works. Unless we know how the actual industry works and what is industry, just 5 minutes, a brief introduction.
Yes, Mr.
My lord, if your lordship just sees my written submission,
Where are you written submission?
1E, and please come to page 12. Page 12. PDF 30. With a color code, madam. Lordship has got it. All your lordships have got. I'll just wait. Now, while it is being searched, as your lordship rightly put it, the universe of regulation is entirely with the states. The split takes place at the time of removal, as Justice Jeevan Reddy notes in the Law Commission. When you split, if you're going for industrial, you pay excise duty. If you're going for IMFL, you pay state excise duty.
No, I'll follow on this. You may continue.
All your lordships have got it.
It's here.
Yes. Now, my lord, I've discussed this with people from the industry. Now, my lord, the source of alcohol is basically 2 substrates. Either it is molasses or it is grain. Now, my lord, molasses and grain are subject to fermentation, adding yeast and so on. And there used to be what is called primary distillation, which results in rectified spirit, or RS. Rectified spirit is about, can be 80-90% alcohol. From rectified spirit, there is a secondary distillation, which results in ENA, extra neutral alcohol, which is, your lordship sees, it comes to ENA. If the same secondary distillation is from grain, it is called GNS, grain neutral spirit. It's called neutral because it is most of the impurities have been removed. And ethyl alcohol can go up to 99%, but the industry tells me that the cost of taking it from 95 to 99 is very huge and the benefits are not much. So typically they use 95% of ENA. So if I start a distillery and I get a state license, I will either get my substrate from molasses or from grain. I will make rectified spirit. And now I'm told in the modern days with technology, you go straight from substrate to ENA. You bypass the rectified spirit stage, you straight away go to ENA. And I'm also told that except Maharashtra and one more state, all country liquor is based on dilution of ENA or grain neutral spirit. So in UP, for whom I appear, the country liquor has got 26% potency. That's how, and so one brand is 26%, one brand is 32% in UP. So ENA is diluted to that. Now please see the chart, Mala. So a distillery.
Your chart doesn't have rectified spirit in it.
No, actually, between molasses and ENA, it should be rectified spirit. This is the modern technology. I'm told that in most cases now they go straight to ENA.
Oh, I see.
So if a lordship doesn't mind, between molasses and this, if a lordship can add rectified spirit. Now, my lord, once I get extra neutral alcohol, 90-95% of the output goes to manufacture of liquor, IMFL or country liquor. a smaller percentage can be used in various industries, paints, varnishes, perfumes, and so on. Now, when I get a license to make extra neutral alcohol. If I want to clear a percentage for industrial purposes, I must file form DS1, DS2. Lordship, ignore the procedure. I have to file DS1, DS2. A state excise officer will be present in my premises. In his presence, the portion of the alcohol I want to sell for industrial purposes will be denatured. Once it is denatured and it is removed to a paint manufacturer or a perfume manufacturer or somebody else, it will suffer a central excise duty and be cleared. But even at the stage of denaturation, I have to pay denaturing fee. And there are 3 categories of denaturants which are given. Now, somebody asks, can you make denatured spirit and drink it? I discuss the matter. It depends on the nature of the denaturant. There are different types of denaturants. If the denaturant is methyl alcohol, or it is just one molecule less, ethyl is C2H5OH, ethyl alcohol is CH3OH, just one carbon less, 2 hydrogen less. But methyl alcohol results in blindness, definitely, and death beyond a point. So the Lordship sees these huge tragedies, illicit liquor tragedies we get in the press now and then. That is because the bootlegger or the illicit manufacturer, he does not know what is the denaturant. He gets somewhere from some illegal sources, he gets that, he dilutes it, sells it. God forbid if it is methyl alcohol and this, Lordship will see in the press, people turn blind, if there's some other denaturant, it could still cause vomiting, sickness, nausea, but it may not cause blindness and death. So this is the whole thing. And there is a prosecution and punishment of anybody attempting to make denatured spirit into renaturing. It is punishable with fine and imprisonment up to 2 years. That's the law. So now, my lord, just completing this chart and I'll go to synthetics. So Lordship will find if I want to sell industrial alcohol, then actually industrial alcohol should not be used. I would beg your Lordship to call it denatured spirit. Industrial alcohol that's the fountainhead of the confusion that has been created. I'll point out later. It is denatured spirit. All definitions say spirits include denatured spirits. And a denatured spirit is a spirit to which denaturant is added. In fact, there are denaturant rules. And interestingly, my lord, sorry. Interestingly, my lord, suppose I import extra neutral alcohol. The duty is 150%. Once it is denatured, there's a denature process at the port itself. You can get it denatured. Then the duty is 5%. Now it has become 0%. So denatured goes for industrial purposes. They kept the duty at 5. When it is meant for ENA to be cleared for making, say, for example, many ENAs are brought here, then they are blended in India and they are again sold. So they suffer duty at 150. So I'll show your Lordship customs also. And to show your Lordship that intoxicating liquor means everything. What happens is, because if Lordship sees this entire universe is entry 8.
Right.
When it's going out, it is entry 84 of list 1 or entry 51 of list 2. Now Lordship sees, if I go to IMFL, Lordship will kindly see what is added in whiskey, what is added in rum, brandy, gin, vodka, nothing is added. These are the categories. But beer is a separate entry. Beer, the level is about 8%. Wine is about 18%. Now, Lordship will just note, just for completing, in India, you cannot sell by law liquor containing more than 50% strength of alcohol. It's banned. But there are certain brands which are sold, which have got a higher content, but they're only for export. But I've got photographs. I didn't want to make it more colorful. I got photographs where there are Polish vodkas which are 92% strength. I don't know how they will be adding 1 liter of water to that. I don't know how they're drinking, but I've got photographs of alcohol 60-70% is very common. So this is the strength. Now, my lord. So this is the entire structure of the industry. Maybe extreme cold in Siberia. Yeah. Now, my lord, so my humble submission is, when we understand intoxicating liquor, what the state does is, it can regulate both liquor meant for human consumption called potable alcohol. It can also regulate denatured spirit, because denaturing takes place within that premises itself. Now, I would humbly submit that synthetics and chemicals, this is my second argument, no? Synthetics and chemicals is liable to be overruled by your lordship, because the fundamental flaw is that their lordships mix up industrial alcohol and rectified spirit to be synonymous. They say industrial alcohol is rectified spirit. In one more place, they say industrial alcohol is ethyl alcohol. So they fail to note the distinction between rectified spirit or ethyl alcohol, which per se is for human consumption. Secondly, my lord, as Justice Jeevan Reddy also notes from the Law Commission, and your lordship also pointed out, there is no word of industrial alcohol anywhere. It's a loose commercial term to say the spirit is denatured. The second error, my lord, which synthetics and chemicals makes, is that they read the entry 51, which uses the phrase alcoholic liquor for human consumption, mistakenly as alcoholic liquor fit for human consumption. There's a world of a difference. But the third error, which has been another Supreme Court judgment said is per imperium. Synthetics goes and says that states can't even levy sales tax. And that was held to be per imperium in 1991 4 SCC 139, but lordship need not trouble yourself with that now. The sales tax is not an issue. Well, I can give a full note if the lordship doesn't, to save time, I can give a note also.
Yes.
I'll give a full note. Because I had made my written submissions, but in the light of so many questions, now I have to recast what I did. But the other fourth error, which is an inconsistency. In the earlier part, they say states have nothing to do with alcohol. But in the later part, they say, yes, you can levy regulatory fee. Now you can't have both ways. So, my lord, I'll straight away go to the paragraphs of synthetics, and then I'll make my submissions on entry 33, IDR Act. Yes, I am. Volume 30. Lord, I'll just read 4-5 paragraphs of synthetics. Then I'll go to the most important amendment, which completely changes the situation. Lordship will kindly come to first para 41 of synthetics and chemicals. It's volume 5, PDF para 37. This is to say that union has taken a stand.
Just one thing. Volume 5, page.
Volume 5, PDF page 37. The judgment starts on PDF page 9.
Page 29, 37, 29.
I read para 41. Lord. Para 41. Which one? Lord, this is the judgment which is now for reconsideration. Please see para 41. The only question which has to be determined is whether intoxicating liquor in entry 8 in list 2 is confined to potable liquor or includes all liquors. According to the Union of India, in view of the difference of language in entry 8 and entry 51 of list 2, it is reasonably possible to take the view that intoxicating liquors include both liquors. They took this stand before the 7 judges. Now, please see further. It was submitted by the Union of India that there are no grounds for overruling Balsara case decided in 1951 after 38 years, particularly when it has been followed and applied in later decisions. But the judgment then later goes to say Balsara is wrongly decided.
Yes.
Now, my lord, just see below that there's no placetum here. Lordship will see it was submitted in India Mica and Micanite case, where Lordship saw, my lord, they held India Mica. They said the word intoxicating liquor will include denatured spirit, but they said you only can levy fee. Excise duty goes to the center. You can levy regulatory fee, and they remanded the matter for reconsideration. Now, Lordship will kindly see. They notice India Mica. Now come to para 86D, which will be at page PDF page 58. Para 86D. However, in case state is rendering any service as distinct from its claim of so-called grant of privilege, it may charge fees based on quid pro quo. See in this connection observations of India Mica. And Lordship will kindly see para 86. The position with regard to control of alcohol industry has undergone material significant change. After the amendment, the state is left with the following powers in respect of alcohol. What alcohol are we meaning? So, my humble submission is, the union has taken a categorical stand that entry 8 includes both. Balsara was right, and this 7-judge bench notices India Mica, but says that yes, part of it is correct. Now, what are the errors in the judgment? I'll just point out the errors. Now, please come to para 74. PDF page 54. Para 74. May I read? Have all your lordships got it? Para 74. Yes. My lord, Justice Masi has got it, my lord. Para 74. Para 74.
It's there in the display.
It has to be borne in mind that by common standards, now this is the, if I may say so, the main error which completely by common standards, ethyl alcohol, which is 95%, is an industrial alcohol and is not fit for human consumption. The petitioners and appellants are manufacturing ethyl alcohol, also known as rectified spirit, which is an industrial alcohol. I would humbly request your lordship to hold that this observation is incorrect.
Observation that
Rectified spirit or ethyl alcohol, after undergoing denaturation, then becomes industrial alcohol. This is an anterior stage. It has to be denatured under the denatured rules on payment or denaturing fees, and then becomes industrial alcohol or technically industrial spirit. ISI specification has divided ethyl alcohol as known in the trade into several kinds of alcohol. Beverage and industrial alcohols are clearly and differently treated. Rectified spirit for industrial purposes is defined as spirit purified by distillation having a strength not less than 95% volume. Again, this is wrong. Rectified spirit per se has no purpose. Rectified spirit after denaturation becomes unfit for human consumption. That's it. Then please see further, madam. Dictionaries and technical books also show that rectified spirit is an industrial alcohol and is not potable as such. Again, completely wrong. It appears, therefore, that industrial alcohol, which is ethyl alcohol, by itself is not only non-potable but is highly toxic. If these passages are overruled, then the entire law gets into place. And I'll show your lordship that this is not just my argument. Kindly see how it is classified in Customs Act, for example. How they split it. Take the custom. Lord, I'll do one thing. I'll finish the other portions which require correction, and then your lordship will kindly see. Lordship, just bear with me, Lord. I'm also learning like Mr. Dwivedi. Come to para 52, madam.
para
52 at PDF page 42. May I read me? I'll just please come 7-8 down lines down the line. The industry needs potable alcohol. Lordship is no, sir?
yes.
The industry needs potable alcohol and denaturants are not required by it. Rather, some of them are avoided according to state of it. No, this is just the reverse. Industry doesn't want potable alcohol. Industry wants denatured spirit. Human beings want potable alcohol. Then please see further. The industry needs potable alcohol and the denaturants are not required by it. Rather, some of them are avoided according to the state of UP. In particular industry, they hamper the manufacture of final product. Denatured spirit or industrial alcohol is basically potable alcohol. It is denatured in public interest to prevent its use as potable alcohol. Then please come to para 54. Next page. Para 54. We have no doubt that the framers of the Constitution, when they use the expression alcoholic liquor for human consumption, they meant at that time, and still the expression means that liquor which, as it is consumable in the sense capable of being taken by human beings as such as beverage for drinks, which is not correct. If a lordship goes back to my chart at page 12, there are many companies, basically not sugar industry, they have molasses. So from molasses, they make ENA. And that ENA is then sold to, say, XYZ companies which make different kinds of products. So what happens is, ENA from the sugar factory or the sugar industry is potable alcohol. It may not be fit for consuming as it is, but it is alcoholic liquor for human consumption, and we pay excise duty on that. And to make the technical point very clear, what happens in UP is when we clear it to a distillery within UP, the duty is paid at the IMFL stage. It is moved in bond. The entire movement is controlled by the state. And then depending on what you buy and the selling price, they levy the excise duty. Because the product may vary depending on strength, etc. So this statement that alcoholic liquor for human consumption, my humble request is, please do not add the verb fit for human consumption in that place. Alcoholic liquor for human consumption means alcoholic liquor which is capable of being used for human consumption. And Lordship knows Anwar Khan's case 11 STC, they say consumption, Article 286 before the amendment, it said consumption. Anwar Khan said there is consumptions and final consumption. So even at the earlier consumption also it's all right. So consumption by itself does not mean final consumption. Even at the earlier stage is good enough. So my next request is subject to your Lordship's approval. Alcoholic liquor for human consumption means if the alcoholic liquor is capable of being used for human consumption, it will come under entry 51 of list 2. If it is denatured, it will come under entry 84 of list 1. And I was told that when I apply for the license to the state, I don't say how much denatured I'll make, how much this I'll make. It's my choice. It's a demand and supply. Suppose tomorrow there's a, like say for example, prohibition is imposed in Bihar. I don't know what's the situation. Automatically IMFL demand will go down. It will have to be more used for industry because there's no, unless it is exported from that state. So the factory which gets the license or the sugar company which gets the license will pay the duty depending on how much they clear. Today they may clear 100 tons, etc. So this is the law. So this also in my humble submission, para 54 is wrong. So my request is para 74, para 52, which mix up between ethyl alcohol, rectified spirit, and treat them as industrial alcohol, deserves to be overruled. The statement in para 74 that what alcoholic liquor which is contemplated in entry 51 and entry 84 is as it is. My humble submission is Article 47 use the word intoxicating drinks. That may be something which is ready to use, but not here. Then, my lord, the other error which requires to be reversed, please come to para 85. Yeah, 85. Yes, para 85, page 57. I showed it. Para 85, my lord. Page, sorry, 57. Para 85. After the 1956 amendment, all your lordships have got it. After the 1956 amendment to the IDR Act, bringing alcohol industries under fermentation industries as item 26 of the first schedule to the IDR Act, the control of this industry is vested exclusively in the union. That is incorrect. I will take your lordship to the IDR Act and show how it is not exclusive. And just now, I'll just simply point out, entry 26 uses the word trade and commerce. 27 says production, supply, distribution. So 2 plus 3, 5. Entry 33 says trade, commerce, production, supply, distribution, all 5. 18G talks only of trade, commerce, supply, distribution, nothing on production. Essential Commodities Act, all are included. I'll come to that shortly. So this observation is not correct. Please see further, Milon. Thereafter, licenses to manufacture both potable, non-potable alcohol is vested in central government. It's absolutely incorrect. All of us know that licenses to manufacture liquor, it is entirely a state subject. Distilleries are manufacturing Distilleries are manufacturing alcohol under Central License and IDR Act, also not correct. No privilege for manufacture, even if one existed, has been transferred to the distilleries for the state. Now, just pausing here, their lordships say they criticize the police power theory and says we'd not like to use police power, we'll use the word sovereign power. My humble submission is that's a separate controversy whether police power is there or not there. So when the lordship writes a judgment, I would request that that can be kept open subject to my lord's approval, because nobody's arguing on is there a police power. There is a sovereign power. Let's go by that. Because just to clarify, my lord, this aspect of police power came with the 18th Amendment to the US Constitution. Lordship knows they imposed prohibition in the US in 1919 by the 18th Amendment. It was repealed by the 21st Amendment in 1933. So US had prohibition from 1919 to 1933. I've got a US Supreme Court judgment which says they use the word intoxicating liquor, the 18th Amendment. And intoxicating liquor, the US Supreme Court said includes denatured spirit. So lots of like to see that, or I'll just give the page number in my note. So to say that, Lord, privilege is not there. I don't quarrel with that for the time being. Since it's a 9-judge bench, if a lordship is supposed going to approve or overrule, that police power may be left open is my request. Now kindly see further. The state cannot itself manufacture industrial alcohol without the permission of the central government. Sorry, no. I don't need central government permission. I will make ENA. If I clear ENA for after denaturant, I will pay the appropriate duty. The states cannot claim a right they do not possess, nor can the states claim exclusive right to produce and manufacture industrial alcohol, which are manufactured under the grant of license for central government. But I could be wrong, but what research I did was there is no industrial licensing for any industrial alcohol. Only one thing I am told now, this popularity of ethanol being used as additive to fuel. So there are plants which are being only denatured. I mean, they don't make potable. They make complete ethanol based on a formula, which is then added to petrol or so and so, so and so. That's a different aspect. But to say that industrial alcohol is manufactured under grant of license is technically incorrect, because industrial alcohol is never manufactured. What is manufactured is ENA. ENA is adulterated or denatured. It remains an alcohol, but it's an alcohol which can't be used by human beings. So there is no question of manufacturing industrial alcohol. You manufacture only ENA. Then there's a fork in the road.
The license is obtained to manufacture one basic item, ENA, and then you convert it subject to demand.
Yes.
And depending upon that, whatever the implications of regulations, etc.
As Malad Chief Justice said, then the tax part comes in.
Tax part comes in.
Yes.
Could be central excise or it could be state.
Yes.
But then this is something very straightforward confusion. I am just wondering, these 7 judges, they had no polished roots. You said they drink very potent liquor in Poland because they, I think, were influenced by 97% alcohol and heady argument.
Or perhaps the lawyer didn't consume enough.
Of not knowing the progress in the field.
No, actually, what happened was,
Of industrial alcohol.
with great respect, as my learned friend, if the lordship sees opening paragraph, please see para 3 and 4 of the judgment. What is the controversy? UP levied vent fee on industrial alcohol. These people challenged it. They said this vent fee is actually a tax in disguise. It's masquerading as a vent fee, but actually it's a tax. Then the court went into, and then what happened was the assessees took the point that state has no power to levy vent fee at all. That issue is actually settled by Indian MICA. What they say is you can levy regulatory fees, but if they are disproportionate, if they're high, then they'll be subject to challenge as arbitrary, excessive, or then what happens? You misusing the power of fee to actually levy a tax, that can't be done. That's again settled. So, my lord, these are the erroneous paragraphs in this particular thing. Now, let me go to the Law Commission report. Now, what happened was, after 1990, there were a number of judgments on both sides. Sorry. we are both for UP. So we are basing our power to levy fees on the sovereign power on this constitutional provision. We are not claiming privilege and so on, which is a different subject altogether. Yes, I.
Yes.
In fact, this is Venkatramaiah in CSS Transport, which is quoted with glowing tributes later by this is B.K. Mukherjee. He says that privilege is basically a royal prerogative. And if your lordship asks me frankly, in a Republican constitution, privilege may be an anachronism. Nobody, we are all citizens. Either I get the license or I don't get the license. Nobody is giving me privilege. But we use privilege in the same of typically what happens, whether it's telecom or petroleum or alcohol, whatever was a state monopoly. They say state is allowing you to make therefore state is parting with the privilege. But I don't want to waste time on that. No? Lordship will now come to. No. Now, please straight away come to the Law Commission report.
It's a privilege, then
Which volume?
Yes, which is volume 4, 4A, page 559. I'll read the opening letter. Well, after synthetic, there are a lot of representation from different states. Because synthetic said that, sorry. Yes, 559. Lordship got miss page 560, the covering letter. I read. Para 2, The subject was taken up by the Law Commission on its own. The need for taking up the subject is on account of the emergence of several practical problems as a sequel to the decision of the Constitution Bench of the Supreme Court in the case of synthetics and chemicals and others versus so and so. The import of the said synthetics has caused inconsistency in latest Supreme Court decision discussed in Chapter 2 of the report. The report seeks to do away with the doubts so that the conflicts in discharge of functions, etc. But my humble submission is that I need not go into the decision both for and all because your lordships are untrammeled by precedents. So we can straight away decide on first principles. But this is the reason why the Law Commission took it up. Just please come to page 572, which is PDF page, same thing. Paragraph. Almost every state, almost every state has an excise law in force. Some of them enacted prior to the commencement of the Constitution, governing the manufacture, distribution, sale, and possession of liquor. The definition of liquor in these enactments made no distinction between liquor used for human consumption and liquor used for other purposes. These acts purported to regulate all liquors. The excise duty on the manufacture of liquor was collected by the state governments, which also closely regulated and controlled the manufacture, possession, and transfer of liquors. As a fact, and speaking generally, the union had no say in the matter. Now, Lordship will come to page 580. At same PDF page. 2.2.1, nature of problem created pursuant to so and so. The decision of the Constitution Bench created several practical problems, as explained in the later decisions of the Supreme Court to be referred to presently. There is no such thing as industrial alcohol. What is manufactured is alcohol, namely of 95% above purity, which it appears is known as ethyl alcohol and also as rectified spirit. This rectified spirit can be used for both industrial and non-industrial purposes. And then his lordship gives the example of excise, where the taxable event is manufacture, but the collection is the time of removal. So here also, the time of removal is important. Now, and then the conclusion, please come to the conclusion. So the report is accepted. What's the conclusion page? Sorry, 1 minute, Lord, I didn't make a note. Yes, now page 595. para 3.1, chapter 3. Lordship has got it? Yes. Chapter 3. Having observed in the preceding chapter the apparent conflict in the Supreme Court decisions on the import of the important subject relating to item 26 of the first schedule, it is quite essential to do away with the doubts as early as possible so that conflicts and discharge of functions of the central and state governments are reconciled as held in Murari so and so. Before embarking upon the effect to seek a solution, it's pertinent to refer to the argument. Well, when he refers to Bihar Distillery, which actually was judgment by Jeevan Reddy himself. Now, Lordship will kindly see paragraph 599. Consideration of the problem and recommendations. I'm not going into it because ultimately the government accepted this report. Yes. Now, please come to 602. The Law Commission of India is of the opinion that the above matter should be clarified by enacting appropriate amendments to the IDR Act instead of leaving the matter to be fought out in courts. This controversy has already attracted 4 or more judgments and the confusion has not been cleared. In the interest of maintaining balance between union and the states, and also with a view to eliminate room for abuse and misuse of abuse of law and misuse of alcohol, to enable the states to levy and collect income which they were receiving by levying excise duty on alcohol for more than a century prior to the decisions in synthetics, and also to put an end to legal wrangling, it is eminently proper and expedient to substitute the following item in the first schedule to the IDR Act in the place of the existing item, fermentation industries, but not including alcohol. The NK only said industry, the Lordship said add, not including alcohol. Now, then they finally conclude. Please see page 604. The Law Commission recommends substituting item 26 in the first schedule, fermentation industries, but not including alcohol. What Parliament did was they put in brackets, not potable alcohol. Now, Lordship will come to the Act. Yes, I'll take a Lordship to the Statement of Objects and Reasons, which is volume 4A, page 830. Same volume.
What page is it?
Volume?
830, my apologies.
In that same.
Same. Yes. Number Lord, I'll read para 2. Para 1 is just the preamble. May I read, Lord? All of you, Lordships. According to the distribution of legislative powers contained in the 7th schedule, entry 8 of list 2, state list enumerates the subject matter intoxicating liquors, that is to say so and so. And entry 24 thereof enumerates the subject matter industries subject to provisions of entries 7 and 52 of list 1. While entry 7 of list 1, union list provides for subject matter industries declared by Parliament to be necessary for defense. Entry 52 thereof provides industries, the control of which by the union is declared by Parliament by law extend public interest. Thus, the authority to regulate the subject matter intoxicating liquors appears to vest in both union and state. This has resulted in prolonged litigation. But I'll show how that is not correct, but for the time being, yes. The Supreme Court in the case of Bihar Distilleries has held that in the interest of proper delineation of the spheres of the union and the states, the line of demarcation should be drawn at the stage of clearance or removal express. Lordship, that's most important. The demarcation, the division, the split should be drawn at the stage of clearance or removal of the rectified spirit. Where the removal or clearance is for industrial purposes other than manufacture of potable liquor, the levy of duties of excise and all other control shall be with the union, and where the removal or clearance is for obtaining manufacture of potable liquors, the levy of duties of excise and all other control shall be with the state. I will explain that this control doesn't mean regulatory control, it's only control by taxation. Please see further. In the backdrop of the our judgment of Supreme Court, the Law Commission India has recommended in its 158th report that heading 26 of the first schedule to that be substituted as fermentation industries, but not including alcohol. The recommendation of the Law Commission was examined in depth by the government. It's very important. if the subject alcohol is taken out of the first schedule to the Act, both industrial and portable alcohol would come under the purview of state government, which is not in consonance of the judgment of the Supreme Court. Moreover, the effect of implementation of the recommendation of the Law Commission would be that the subject alcohol, which covers both industrial alcohol and portable alcohol, would no longer be a central subject. Therefore, it is proposed to amend the first schedule to the Industries Development Regulation Act by substituting heading 26 thereof, fermentation industries other than portable alcohol, so that it would be in conformity with the judgment of the Supreme Court, and also ensure the Supreme Court is not synthetics but Bihar distilleries.
Exactly what you said yesterday.
This conformity Supreme Court, Lordship will see the conformity Supreme Court is not 1990, it is 1997 Bihar distilleries. So Parliament accepted the Bihar distillery view.
Yes.
And also ensure that the industries engaged in the manufacture of alcohol meant for portable purposes shall be under the total and exclusive control of states in all respects. Kindly note. And ensure that industries engaged in the manufacture of alcohol meant for portable purposes shall be under the total and exclusive control of state in all respects. And that, Lordship, see my chart, the figure I gave at page 12. If I make ENA, till the stage of removal, everything is with the state. Removal, tax, that's all. Two different taxes. The central government would continue to be responsible for formulating policy and regulating foreign collaboration, foreign direct investment, so and so, for all products of fermentation industries, including industrial alcohol and portable alcohol. So, my lord, for formulating policy, foreign collaborations, etc., it will be central. Now, kindly see the amendment. The actual amendment, Lordship will kindly come to page, the actual act. It's at volume 4, page 601.
Page?
Volume 4, page 601. Lord, this is the statement of objects and reasons there, and now I'm going to act is in a different place. Please see clause section 3 of the Act. Lordship will kindly see it as Act was received presidential assent on 14th May, and kindly come to 3 first, then I'll come to 2. Lordship has got 3. The 2 is a validation clause. Come to 3, please. On and from the date of commencement of the principal act in the first schedule for the heading 26 fermentation industries, the heading fermentation industries other than portable alcohol shall be substituted. Now kindly note, from the commencement of the principal act. Retrospective. Sorry, my lord, page 6, not volume 4. Volume 4, my lord, I'm so sorry. My lord, the Chief Justice has got it, my lord. 601 is the act starts. Lordship will note presidential assent is on 14th May. And kindly come to section 3 first. I'll come to 2 later, which is the savings clause. On and from the commencement of the principal act. There is a small mistake here, but I don't want to make much of it. But the main act came in 53 or 52. The first schedule came with the act. It was fully substituted in 56, just as Jeevan Reddy notes that. And 26 was added in 56.
Right from the date of the original.
It's okay, no, it's all right.
When earlier entry was not there at all.
Yes. But doesn't matter. The minimus non-curat lex, as they say.
That's right.
Bother with trifles.
With deemed entry.
Huh?
Deemed entry into the schedule.
I don't know if this got alcoholic effect or not, but it is.
Just to see, you see, my device, it just fell off. And I said, so much alcohol there, I think there's a physical effect.
One thing a lot will agree, my lord, this is much better than mines and minerals. Now, Lord, please see 29E, Validation Act.
See section 2 there.
Yes, I'm going to Validation Act. Now, if they make it retrospective, then what happens to everything?
Yes.
So they say, save it, don't disturb it. That's all they say. If the Lordship wants me to read, I'll read it.
That is the validation.
Validation, notwithstanding anything contain any judgment, because 29E became necessary because of the retrospective amendment. If the amendment was made prospective, there was no need for 29E. Yes.
No, there, if you see this 29E, it's as if the state is deemed to have the power.
Yes.
That
yes.
means what?
No, Lordship will kindly see.
Shall be deemed to be and shall always be deemed to have been.
For all purposes, yes. What happens is many acts have been done after synthetics and chemicals. Number of judgments came. Now different states have taken different views. Madras High Court has got one view. Another High Court has taken. Allahabad has taken a different view. Now, if you're going to have a retrospective amendment, you'll be completely opening up everything.
Therefore, it did not have the power, but they exercised that power. Now it is being validated.
Yes. Yes.
By making this amendment.
Well, I'll put it in a general way. Whether you had the power or not, whatever you have done is saved.
Is now saved.
Yes.
Whatever is done by central and state both.
And both has
Yes,
been
that's
saved.
right.
But same thing in the Vodafone amendment, when they made it retrospective, they had to issue a circular saying all closed assessments will not be reopened.
Right.
Otherwise, it becomes
to state
difficult.
government now. The amendment.
Now, Lord, with this, Lord, I'll now go to the constitutional provisions. Please see entry 33 of list 3. Sorry. Lord, I've just got only 2 points, so I will not take much time. What is the scope of the entries in addition to what my learned colleague has said?
What is the effect of this amendment now?
The effect of this amendment now is this. From the beginning, the control of the states on the manufacture of potable alcohol is absolute. If that is correct, they unfortunately use the word potable alcohol. So they want to say that suppose there is an industry which is making alcohol which is not potable. For example, you can have butyl alcohol, you can have isopropyl alcohol, they're different alcohols. The intoxicating liquors are those which have ethyl alcohol, basically, primarily. Because methyl, you go blind. So it may intoxicate you, but it will be fatal. So what they say is, suppose there's a fermentation industry. I get a license to make only an alcohol which is not potable. Then I will come under the first schedule. But if I got a license like most sugar industries or in those states where there is no sugar, they have grain. So I'm told they buy it in bulk from Food Corporation of India and that grain is fermented. That will be completely coming under state control. And there, the only role of the central government will be to collect central excise duty when it is cleared from my factory. So if this factory gate is there, what goes for IMFL will be state excise, what goes for industrial will be central excise, as my Lord the Chief responded. Now I come to, I've got only do 2 things, explain my own submission on entry 8 and on the provisions of IDR Act, and I have done that. Now please come to, before coming to entry 8, I think your Lordship will come to entry 8, doesn't it? Please come to entry 8. It has already been explained, it's not being made subject to, it's a complete standalone provision and so on. Now, yesterday, my Lord, your Lordships, including my Lord the Chief, just asked, in one sense, entry 52 gives Parliament full power. It can declare any industry to be under its control. At the same time, entry 8 is not subject to provision. The interplay of this entry has been explained in SIEL case by Justice Sujata Manohar. I'll come to that after lunch. But Lordship will kindly take on a first principle reading. My humble submission is entry 8, Lordship will kindly see, intoxicating liquors, that is to say. Now, in the list 2, this that is to say is used 4-5 times. And my humble submission is when they say that is to say,
it's exhaustive.
Exhaustive. And as the Lordship pointed out yesterday, it's production to sale. That is from the raw material to the factory, it leaves the factory. And purchase and sale can also mean second sale. They can control second sales, first sales. It not only B2B, it can be B2C also. Now, my humble submission is 246.2. I'm going to just make submission on 246.2, 246.3, and 254. Because, sorry, Lord, one must make a clear distinction between what is competence and what is repugnance. A law can be made by Parliament under List 1 on a subject matter. The same can also be made by the state under List 2. For example, banking, List 1. Money lending, debt relief, List 2. So regulating interest or banning higher interest can be a state law, can be a central law. How do you decide? Now, there could be a law which Parliament is competent to make. There could be a law which state is competent to make, like interest. Then which will prevail? There, my submission is, if both the laws are, first test which is decided is on competence. This law is made by a state legislature. Is it competent to make it? We have to decide that. Once it is competent, then go to Parliament. Parliament has made a law. How do you decide the repugnance? Please see 254.1. I'll first say take 246.2 and 3, then I'll come to 254.
In the context.
After lunch, just 5 minutes short
Oh,
of
yeah.
lunch.
But I'll try to finish as fast as others are waiting. I'll finish as fast as possible.
Yes, Mr. Datta.
Lordship may straight away go to article, not my. I want to wrap up as early as possible. I'm going to refer to 366.12a GST, then go to entry 8 and go to entry 33 and I'm finished. Please come to article 366.12a. And then your Lordship will.
Article 366(12)A.
Yeah, your Lordship, there's a definition section, as the Lordship knows.
Yes.
And they have defined GST by the 101st Amendment. Yes, one second.
Any tax on supply of goods
Indirect,
or
yes,
services
this
or
thing.
both,
Yes.
except taxes on the supply of alcoholic liquor for human
For
consumption.
human consumption. Now, Lordship will note that taxes on the supply of human consumption. So now that central excise duty, state sales tax, all is subsumed into GST, which becomes a concurrent levy, both center and state. Lordships, Mohit Minderal's Lordship
Yes.
said that. What is left for the states is alcoholic taxes on supply of alcoholic liquor for human consumption. So these taxes on the supply of alcoholic can be by way of excise duty or other imposts. Now, if your Lordship just goes to entry 84 for a minute, the pre-amended entry 84. Entry 84. It will be in the footnote. Now, please see the new entry after the 101st Amendment. Lordship got it? Yes. Duties of excise on tobacco. I'm seeing the footnote. Now, Lordship, on tobacco and other goods manufactured or produced in India, except alcoholic liquors for human consumption. That was
Sorry, you're referring to entry
entry 84, my lord, old entry.
84, prior to amendment.
In the list one, sorry, my lord. At the footnote,
Yes.
duties of excise on tobacco and other goods manufactured or produced in India. But the
Yes.
unique thing that tobacco is an agricultural product. All excise duties on manufactured goods. Tobacco is the only case where it is levied on an agricultural product. But I'm on except alcoholic liquors for human consumption. That Lordship will now come to entry 51 of list 2. Which is the taxing part. Entry 51 of list 2. Duties of excise on the following goods manufactured or produced in India, in the state, and countervailing duties at the same or lower rates on similar goods manufactured or produced elsewhere in India. So, my lord, if liquor is imported from another state into one state, they can levy CVD, just as on import from other country, we can levy CVD.
Right.
That is to balance, because it can't be that one state levies 20% tax, other state levies 10%.
Right.
Then becomes an arbitrage for tax evasion. So they neutralize it. So that can be a countervailing duty. Duties on excise on the following goods manufactured: alcoholic liquors for human consumption. So
what is taken out of entry 84 is introduced in entry 51.
51. So what happens? Yes, except. So the concurrent power under Article 246A. Article 246A says tax on supply of goods or services.
Right.
That is defined in 366(12)A.
Yes.
Just as after the 46th Amendment, tax on sale of goods is now defined in 366(29)A, like that.
Right.
So the net result is, today, if it is an alcoholic liquor for human consumption, call it potable alcohol, call it every alcohol, I would humbly submit that the proper way of interpreting, for your Lordship's stand consideration, is to take it in the reverse. Everything except denatured spirit will be alcoholic liquor for human consumption. Because unless it is denatured, it is alcoholic liquor for human consumption.
Everything except
Denatured spirit. Because since your Lordship is sitting in 9 judges, we don't want another round of litigation. Is it alcoholic liquor fit for human consumption? At what stage you levy, etc. And the reason, But why I say this also is because of, on this tax aspect, not because of this, we have to also see the economic consequences of what we hold. This is Sikri refers to Richard Posner's theory of law and economics having an interplay. Suppose your lordship says, as held in synthetics and chemicals in para 85, they say it should be fit for human consumption, para 65. Then what happens is state has no power to levy any excise duty unless it's a ready-made whiskey, rum, gin or beer. At the ENA stage, it has no power to levy. That ENA is actually for human consumption. Part of it becomes unfit by adding a denaturant. And why do you add a denaturant? Because the state says, if I'm going to lose my revenue, you better make it unfit for human consumption, then you clear it. So my humble request is, keeping in mind the interplay of law and economics, if a lordship takes the view that it should be fit for human consumption, it will have deleterious effects on the state finances, particularly after GST, where as part of our new fiscal federalism, the taxing powers of the states have been drastically reduced. Today, only source, major sources, alcohol, potable alcohol that is, and petroleum products. And Lordship has interpreted 279A4. They say that once the GST Council decides to bring it into the levy of the net of GST, then state lose the power. But today, the main source of real alcohol. So my humble submission is, if we use the word fit for human consumption and take it to that stage, it will have an extremely adverse impact on the taxes of the states.
In fact, the word fit is not there.
Not there.
For
Is it
human
anywhere?
consumption.
Not there.
Is it there anywhere?
No,
Fit
no,
word.
no, not fit for. I checked whether there is anything.
By interpretation, otherwise it is for.
Yes.
So it is capable of.
Yes. Actually, I tried to do a legal search fit for. I got some 6,000 entries. Wherever there is fit and for, it is showing up. So it became very difficult. Even statutory provisions, I could not say. There's no, only Anwar Khan says that consumption doesn't mean final consumption. As long as the goods can be consumed, it is enough. I'll give you an example, Manoj. Suppose you say rice. Now, rice by itself is for human consumption, but till we make it into put into a pressure cooker and make it into rice, or wheat is converted into flour or atta or maida, it is still wheat. It is still for human consumption. So in the same way, ENA, in my chart, after the secondary process of distillation, first substrate, rectified spirit, ENA. Then we branch out into drinkable or industrial. So my humble request is, keeping in mind 366(12)(a), the power of the states to levy tax should be on extra neutral alcohol. Whatever is not denatured.
Really, in that sense, dealing with tax per se under entry 51, are we?
No,
we are dealing with the ambit under entry 88. Your contention is that we are entitled to levy fees.
No, I'm on a different point. I'm saying that I have to get over the synthetic, because synthetic 7 judges say it has to be fit. In para 65, they say
yes,
it is fit. It's like a beverage. They use actual and they put it in italics with emphasis. Till it's a beverage, state has no power to levy tax at all. That, in my submission, is too extreme from the state's perspective. And it may lead to a conundrum, because so, my lord, sorry, may I continue? So, my lord, this is the request.
Or human consumption is that it may be eventually destined for human consumption.
It has the potential to be
Potential
to be meant for human consumption. That's the point. Now, my lord, I go to entry 8 and entry 33. Entry 8, my submission, my learned friend has elaborately discussed the whole point. My submission is entry 8, as your lordship knows, is not subject to. But my lord, just Nagaratna asked the question, what is the interplay of 246, 2 and 3? There at my
246(1). 246(1) also.
246(1) also. Please see, my lord, 246(1), 2, 3. And I would request your lordship to read it in the context of 254. 246(1), yes. Notwithstanding anything contained in clause 2 and 3, Parliament has exclusive powers to make laws with respect to any of the matters enumerated in list 1. 2. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also have the powers to make law with list 3. 3 is very important from my side. Subject to 1 and 2, the legislature of any state has exclusive powers to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule. So Lordship will kindly see the rule is exclusive power. In the concept of a federal structure, exclusive power is there. And my humble submission is, unless that legislative entry uses the word subject to, the power of the state legislature should be plenary.
But subject to really makes it clear that the power of the legislature of the state is, in that sense, I wouldn't say subordinated to
Parliament.
but is subject to the power of
Yes.
Parliament. And
Very interesting. Very interesting. Now, let's take a law with regard to entry 8. Manufacture, production, possession, transport. Intoxicating liquor. That is to say, manufacture, production, possession, transport, sale. This is given, exclusive power is given to the state. Now, my submission is, if your lordship now reads 254, I am saying the question of competence. Just because Parliament is supreme, it does not mean it can make a law which has been exclusively given to the state.
undoubtedly.
Undoubtedly. So, yes, that's all. So 254, lordship has got the point, so I don't belabor on that. Please see 254. I'm saying, I'm requesting your lordship to read 246(1), 2, 3, and 254 as an overall scheme. (254)(1). I'm not going to 254(2) because entry 8 is not in the concurrent list. Correct. If married not 2, sorry. Yes.
The word subject to clauses 1 and 2.
Yes.
Does that mean that where Parliament has undoubted power to make a law and has made a law in exercise of its jurisdiction to make a law on the union list, the state also has a power to make a law on a subject which falls in the state list?
Yes.
Both have powers and
Yes.
both are acting within their realm.
Yes.
The law nonetheless made by the legislature of the state ought not to entrench upon the law made by by Parliament.
True. But I'm going in one other way. Repugnance will come where it's a law validly made by Parliament. There is another law made by the state. Two can't collide and coexist. Right. Then in that case, supremacy goes to Parliament. So if the two laws are colliding with each other, then Parliament law will supremacy. I am requesting a lordship to interpret entry 8 to mean, please see 254(1). If any provision of law is made by the legislature of a state is repugnant to any provision of law made by Parliament. But what law made by Parliament? Not any law. Please see the next after the comma. Which Parliament is competent to enact?
With respect to one of the matters enumerated in the concurrent list.
Concurrent list. No, there my submission is after comma or to any provision of an existing law. My submission is the first part, that is up to Parliament is competent to enact, can be a list 1 versus list 2 law. Then there is a comma. Yes. Or to any provision of an existing law with respect to any matters enumerated in the concurrent list. Yes. Then subject to. So now the second part, concurrent list, or to any provision of an existing law made. Please see this now. I'll put it this way. There is an existing parliamentary law. That existing parliamentary law is with respect to a matter in the concurrent list. Any law made by the state will be repugnant, will be void to that extent. I'm not on an existing law. I'm only trying to interpret the scope of list 2. I'm trying to say the words between the two commas, which Parliament is competent to enact. If entry 8 has given exclusive power to the states in the context of manufacture, production, possession, transport, sale, Parliament has no competence to get into intoxicating liquor on those fields. Because it's not any law made by Parliament. It should be a law which Parliament is competent to enact. And my submission is that non-obstante clause only talks of a law, competent law of Parliament. Suppose tomorrow Parliament makes a sales tax law. It's not competent to make it. Then you can't say no, Parliament in the federal structure is supreme. That's the submission. So my humble submission is these words are very important, which Parliament is competent to enact. And what I have also this theory that occupied field should not be necessarily restricted to concurrent list.
No, therefore, the scope and ambit of this expression in entry 8 intoxicating liquor is again important.
Yes.
Because if there is something beyond intoxicating liquor,
Yes.
then it can be read in the first part of
Yes.
Article 254,
Yes.
read with subclause 1 of Article 245, 246.
Yes. But my answer.
They go together.
Yes, my answer to that is this. Now, intoxicating liquor has not been defined.
Yes.
It has not been defined. What do we do? Mr. Sirwai goes into various aspects of different types of competence. Gannon-Dunkley, the test is the classic test. Suppose a word is not defined in the Constitution. Then find out if that word is nomen juris. If that word has got a definite connotation over a passage of time, then adopt that. Therefore, what happened in the Gannon-Dunkley's case? The Madras government, then Rajaji's government, amended the word sale to include works contract. That was challenged. And not incidentally, as brilliant as the Supreme Court judgment, the classic Madras judgment is equally good, Justice Satyanarayana's judgment. What they say is, you have got the power to tax sale or purchase of goods. Sale is not defined. Then can you say state government can say sale includes works contract? What Justice Venkatramaya says in Gannon-Dunkley is, sale is not defined. But sale is nomen juris because by tradition, the Sale of Goods Act, which was early in the Contract Act, sale basically means it should be goods, consideration should be in money, and there should be transfer of property, buyer and seller. If those three things are there, it's a sale. In works contract, that is absent. So he said, you can't expand your taxing powers by giving artificial definition to the word. In the context of intoxicating liquor, my submission is, all the acts are here. He has made a complete chart. Spirits Act 1880 says spirit includes denatured alcohol. So intoxicating liquor today, India Mica, FN Balsara, all have said intoxicating liquor includes denatured spirit, because if your lordship sees my chart, the color chart, denatured spirit is born out of intoxicating liquor. In a sense, it's the offspring of intoxicating liquor to which denaturant is added. That's all. So you have molasses, you have rectified spirit, you have extra neutral alcohol, and then one branch goes to denaturing. So my submission is intoxicating liquor in that sense. There is no such thing as industrial alcohol coming out of somewhere. Industrial alcohol is the offspring of intoxicating liquor. And my submission is that subject to in 246(3), your lordship asked, that subject to must be a subject to in the Constitution. And a legislative entry cannot be cut down by a parliamentary law. That's why they say subject to entry 24, lordship mines and minerals, subject to, subject to. Incidentally, in list 1, entry 32 is the only list where it is subject to a parliamentary state law in the Constitution. Now, my lord, so my humble submission is entry 8 should be read in such a way that the state's power is supreme, because tomorrow, if they want to levy a rent fee, a regulatory fee, so we should completely demarcate what is the territory, legal territory for the states. And I would submit, as the statement of object says, let the Lakshman Resha, let the borderline be the time of removal. Up to the time of removal, it is the state's jurisdiction. When it is removed, depending on its destination, it becomes a state tax or it becomes a central tax. Now it becomes a GST. Now, my lord, I go on to entry 33. Lordship will kindly see entry 33 is substituted by Article 36 by the third amendment to the Constitution. And why was it done? My lord, if the Lordship kindly sees entry 33 for a minute.
They added B, C, D, E.
Yes, not just that, there was a small change. If your Lordship kindly takes, I've got the old entry 33. It's just one page, so I didn't put the whole government of India Act. Huh? It's in Tikaram.
Now uses the word industry.
Yes.
The earlier one was in plural, industries.
If your Lordship kindly sees where the control of such industries is, yes, your Lordship is right. Lord, one thing of 33, is your Lordship seeing the old act? No? I'll see the old act and then go. Please see the old one. Trade and commerce in. So Lordship can link it to 26. Production, supply, distribution of. Link it to 27 of list 2. The products of industries where the control of such industries by the union is declared by parliament to be expedient in public interest. Now, why was the need to amend it? Please come to 369 of the Constitution.
They of course also added and imported goods of the same kind as such products.
Yes. No, please see 369. One of the temporary provisions in the Constitution, 369. With the list of Lordship has got 369.
Yes.
Temporary power of parliament to make laws with respect to certain matters. Notwithstanding anything contained in this Constitution, Parliament shall, during a period of 5 years from the commencement of this Constitution, have power to make laws with respect to the following matters as if they were enumerated in the concurrent list. So they take a legal fiction with regard to specified matters, even if it's in the state list, Parliament gets power. Now, please see what are the matters. Trade, commerce within a state, in the production, supply, distribution. Again, they adopt the language of 26 and 27. Cotton and woolen textiles, raw cotton, including gind cotton and gind cotton kapas, cotton seed, paper, newsprint, foodstuffs, cattle fodder, coal, including coke, derivatives coal, iron, steel, and mica. Now, this is what's going to lapse in 1955 because it has a shelf life of 5 years. So if your Lordship sees the statement of objects and reasons of the third amendment, Parliament felt it necessary that though 369 will lapse in 5 years by 1955, Parliament should continue to have control over certain essential items. That's why they came with this substituted entry of 33. Now, please come to entry 33 for a minute. Lordship will note that entry 33 of list 3 Lordship will see, my lord, trade and commerce in production, supply, distribution. So there are 5 activities: trade, commerce, production, supply, distribution. Now come to A, products of any industry. As the Lordship said, now it's industry, where the control of such industry by the union is declared by parliament by law to be expedient in public interest, and imported goods of the same kind of product. B, C, D are some of the items from 369. Not all.
Yes.
Not all. Because iron and steel has gone to IDR Act, coal has gone to Mines and Minerals Act. One more note, distinction Lordship will note. One is industry, A is industry, B, C, D are agricultural items. Mr. Basu in his commentary says this is a cut at federalism. This agriculture is exclusively state, but you put trade, commerce, supply, etc. in list 3. Now, the scope of 33 vis-a-vis 24, 25, 26 has been very well explained in a Supreme Court judgment, SIEL versus Union of India.
No, that is under 369, it was held to be in concurrent list. Therefore, they brought it to the concurrent list.
No, what happened actually,
Under the
your Lordship is right.
Under the
369
temporary powers,
yes,
even though it may be agricultural products, under the temporary powers, it was under the
Yes.
concurrent list.
yes, yes. What they did was they created a legal fiction. They said for the first 5 years, although all these items are in the state list, they will treat it as if they are in the concurrent list.
That's first to give Parliament the power to legislate.
Yes. So now what happened is they didn't want the whole. See, if
So they brought some of those items in entry 33.
yes,
Which is,
which are agricultural items,
Right.
which are agricultural items.
but they continued it in the concurrent list.
Now it's forever. Now it's forever. There's a very nice, very short statement objects. Parliament
Raw jute was not in Article 369. No?
Sorry, my lord.
Raw jute was not in Article
Only
369.
jute was there.
Was jute there?
One second. I'll just subject to memory. My lord, 1 second. No, jute is not there. Your Lordship is right.
So the subjects in clause A of Article 369 were not brought into.
No, not all, not all, not all.
Just these limited
Yes,
items.
yes, yes. Because, for example, my lord, cotton, woolen textiles, iron, steel have gone to Schedule 1 of IDR Act. So they are not in BCD, but they are in A.
Right.
They are in A.
Now what does CL say?
Tobacco also not there.
Sorry.
No, my lord, tobacco not here. Not there. Sorry, my lord.
What does the judgment in CL say?
CL. That shows the interplay of 24, 25, 26 and 52. And they say that what is in entry 33 of list 3 is out of entry 52 of list 1. Yes. Lord, will be volume 5, page 2209, PDF pages 2217. 2217.
Right.
Lord, the initial facts may be slightly important. What was challenged was some molasses order, which was upheld by the High Court and Supreme Court confirmed it. Kindly come to page 2213. 2213. Bench of 2 judges, Lord. 2213. I'll just read para 2 and 4. The appellants in these appeals have challenged the constitutional validity of Uttar Pradesh Shira Niyantaram Adhinayam, being UP Act 24 of 64, which received the assent of the President on so and so. The occasion for this challenge appears to have arisen on account of orders passed by the Controller of Molasses, Excise Commissioner UP, under Section 8 of the Act, read with Rule 22 dated so and so. Now, para 4. Under the said orders of the Controller dated so and so, different percentages of graded molasses were reserved for distilleries and industries based on molasses and alcohol in the state of UP. The reserve quantity under the said orders was required to be sold at prices fixed by the state government. Now, please come to page 2214. They expressly extract 18G. Now, my lord, since your lordship has got page 2214 at 18G, to save time, kindly note, it says regulation, supply, distribution, trade and commerce. There is no production in 18G. The word production is not there in 18G. So out of the 5 items of Entry 26 has 2, trade and commerce. Entry 27 has 3, production, supply, distribution. So 2 plus 3, 5. But here only 4 are there, whereas Essential Commodities Act Section 3, all are included. So the point is, even under the IDR Act, Parliament has not reserved to itself, even by notified order, they can't cut into production. So now please come to para 10, page 2215. They see the entries. What you will just note, entry 8 was not there. Now please come to 11, they refer to Calcutta Gas. Now please see 12 and 14 are important. May I read 12 and 14? May I read? While dealing with entry 24 of list 2 and entry 52 of list 1, this court in the above case considered what was meant by the term industry, which was used in both these entries. This court held that in the first place, where whatever be the connotation of industry, it must bear the same meaning in entry 24 of list 2 as in entry 52 of list 1, because the two entries are interconnected, and giving differential meanings to the word industry in the two entries will snap their connection. This court further observed that ordinarily, industry was in the field of state legislation, but if Parliament makes a relevant declaration or declarations, the industry or industries so declared would be taken off the state list and passed on to Parliament. This court in that case was concerned with the interrelationship of 52 of list 1, entry 24 and 25 of list 2. The last entry expressly dealt with, Your Lordship has seen that, I'll skip it. If we apply the same principle of harmonious construction to entries 24, 26 and 27 of list 2, the term industry in 24 would not take within its ambit trade, commerce or production, supply, distribution, which are the express province of 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade, commerce in or production, supply, distribution of the products of those industries which fall on entry 52 of list 1. For the industries falling in entry 52 of list 1, these subjects are carved out and put in entry 33 of list 3. Now please see 15. I'll just come to placetum E, below that. Just above placetum F. The products of the industry, Lordship has got it. The products of the industry would be comprised in entry 27 of list 2, except where these products were of a controlled industry, where they would fall within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and 27 of list 2 would not be covered by entry 24 of list 2, and similarly, subject matter falling under entry 33 of list 3 would not fall under entry 52 of list 1. I've done only one point. There is a controversy, since your Lordship is sitting in 9 judges. What happens if a law is made but not notified? Suppose Parliament makes a law but doesn't notify it. Does it occupy the field? If a state law is there, will it be repugnant to that? Or there is a Constitution bench judgment of Mar Aprem Kuri, where it says that the Chit Kuris Act, they made a Chit Act by Parliament, but it was never notified. So the Constitution bench says law made by Parliament is different from commencement of the law made by Parliament. So just by making the law, Parliament occupies the field. My humble submission is that may not be correct, because Mr. Dwivedi also read, repugnancy must be in reality. So my submission is, unless the law is actually brought into force, the law made by Parliament must be the law made by Parliament which is in force. Lordship knows the Hire Purchase Act was made in 55 but never notified. Take service tax. 88th Amendment, never notified.
Section 2J of the Industrial Development.
So to that extent, Mar Aprem Kuri, which makes a distinction between law made by Parliament and commencement of the law made by Parliament, may not be good law. Would the Lordship like to cite it, or I'll reserve it later, if we get time in reply, I'll mention that here. Because I'm just submitting, because today what will happen is, state has got the power in the new amendment. Potable alcohol fully comes within the state. Suppose tomorrow Parliament makes some law and doesn't bring it into force. The states can't be completely paralyzed or stultified. So I'm saying that the law made by Parliament will be a law only if it is brought into force. That's why Lordship saw in service tax, they added entry 92C, never notified it. So it was always under 97.
Right.
Deeply obliged.
Thank you, Mr.
2012, 2012, 7 SC 106.
The cash one. That has taken away the list.
Intervention.
Course.
Right, I'm trying to.
In the form of question answers, whatever questions are referred, I gave the answers. But so many questions came from the bench, but I had to restructure it. With the lordship permission, I'll give a fresh.
No problem. Can give it by tomorrow also.
Can it be by Saturday? I have to go back to check.
All.
Yes. Number one.
That judgment you wanted to give.
Which one?
The judgment. you
Mara
wanted-
Prem.
Yes, yes, 1997, sorry, 2007, 2012, 7 SEC, 106, it's a constitution bench,
106.
106. Mar Aparem Kuri Company Limited versus, sorry, State of Kerala versus Mar MAR Aparem APPRAM Kuri.
06.
So they say repugnancy arises as soon as the law is made, even though it is not enforced or made notice. Last year,
It's there in the compilation.
it's in the company?
Yes, yes.
Oh, very good.
It's in volume 5, page,
I'm relying upon it. I'll at my, when my turn comes. It's there in the compilation.
it's there in the compilation.
Volume
Volume
5,
5,
959. 5B,
page 2374.
Volume 5B.
5, volume 5,
come twice.
PDF page
Yes.
2382.
2382.
2382. Volume 5.
Both sides are targeting this constitution bench judgment.
But finally, I appeared for state of UP. Yesterday, I was asked to appear for state of Tamil Nadu. Same submission. They've added something on duty of fee and taxes, which I'm not. I'll be appearing for that. This submission will be common for both.
Yeah.
So the rules are the same. Deeply obliged.
Yes, Mr. Gupta.
My lord, my task is very light, my lord, and I won't hold your lordships up. My lord, I appear for the state of West Bengal, and my lord, unfortunately, there has been a little technical hitch. Our Wakalatnama is filed, my lord, in 901.28. Look, there is a small hitch, my lord. 901.28 is the matter in which, my lord, the state filed its Wakalatnama. Now, my lord, the first thing which happened in this matter was that matter got detagged. So, my lord, we haven't filed it in any other matter. My lord, we'll file it. My lord, our written submissions, my lord, are volume 1H. And my lord, and my lord, the judgments which are not common to my lord what was already filed before us are in volume 5D. The judgments which were common, my lord, we have been told to take out because they are already on record. Now, my lord, my lord, there are two ways in which this matter is being analyzed now, my lord. So I'll just summarize very briefly, my lord. I am not adding, my lord, submissions to the first limb of the argument, which is based on the proposition that all alcohol is intoxicating liquor. And therefore all alcohol is under entry 8 except excise, which takes out a part of it.
No, entry 8 has no fiscal ramification.
It doesn't have, my lord. In any event, my lord, the fiscal ramifications are expressly provided for.
And so provided under separate heads.
Completely separate heads.
No, because you said except excise.
Yes.
That we need not.
No, that's right.
Not necessary.
That's only the end use of the product.
Your basic point is that all alcohol is intoxicating liquor and falls under entry 8.
Yes, my lord. Therefore, my lord, it is excluded from entry 24. My lord, I am just summarizing, my lord, what Mr. Dwivedi has already made it very clear to your lordships, my lord. So it's not included within entry 24. Therefore, not included in 52. List 1. And therefore, my lord, the entirety of the control should be with the state. So, my lord, I adopt that. I don't add anything more to it, my lord. The second aspect of this matter is, my lord, if your lordships do not accept that all alcohol is intoxicating liquor within our entry 8, then what is the position? And my lord, it should be pointed out, my lord, that this proposition was not accepted in synthetics. And so therefore your lordship will have to overrule synthetics on that aspect, that all alcohol is intoxicating liquor.
Has Mr. Datar left? Mr. Datar, you have to give us that Benion's citation on public law. Yes. Because that issue has also arisen before us in the AMU case. Of course, that the issue is a little different, which, and we're not deciding it or commenting, since both the solicitor and attorney will have objections if we did that, as to whether the union can do anything other than to support a union law. Can a union say that a union law is not a valid law? So broadly, jurisprudentially, the same thing. You know, in that AMU case,
Yes.
that issue arose, Mr. Datar had a point because, you know, in synthetics, the union supported Balsara and said that entry 8 covers both liquor for human consumption and what is now called as industrial denatured spirit. So Mr. Datar wanted to refer to an article by Francis Bennion in Public Law, jurisprudential article. Attorney is also interested in jurisprudence, so it'll be interesting to see what it is. So volume?
Volume 5, capital E.
Okay.
PDF page 41.
Just 1 second. Let me see where we had taken. Yeah.
5-E.
Very important. Volume 5E page.
PDF page 41. This is Public Law Volume 2007.
Anyway.
Lordship, since your Lordship asked, colleague just found out this executive estoppel, same article has been cited by Justice S.B. Sinha in two judgments, 2008, 12 SCC 466 and 2009, 16 SCC 569.
2008,
12 SCC 466 and 2009, 16 SCC 569. His
16
Lordship,
SCC 5.
569. 2009, 16 SCC 569. Both by Justice S.B. Sinha.
So you were on the second point now.
Yes.
And you said that alternately, if the court does not accept that all alcohol falls under entry 8.
Yes. In that case, my lord, synthetics has to be overruled on the simple ground that the threefold classification of Tikaram Ji followed up to today has not been taken into consideration at all.
What is the threefold classification of raw materials,
Raw materials,
manufacture and distribution?
manufacture and production, and post-production. Pre-production, production, post-production. Only the second, that is production, is covered by the word industry. So therefore, my lord,
Post-production goes into entry 33.
not necessarily, my lord. It first,
Trade or commerce. Trade or commerce
first
is
is goes into 26,
27
26 and 27.
or 33.
It might go to 33 if the product itself is a notified industry.
Right.
The product, not my lord, the product. Let us say in this case, industrial alcohol is the product. Let us assume. Denatured spirit, my lord, is the better word, as Mr. Datar has already pointed out.
The products of any industry,
Yes.
where the control of such industry is declared by Parliament.
That's right.
So it has to be the product of an industry which is declared by Parliament to be.
Correct. And if raw material is not that industry, it's not part of the industry, it might itself be a product.
Yes. It can be a raw material for some other product.
In this case itself, let's go straight away into, my lord, the real problem. The nub is here. Your lordship has seen the process. It starts from molasses. It goes to ENA, extra neutral alcohol. Extra neutral alcohol is then capable of use in two ways. First, by using denaturing compounds, it can become denatured alcohol and can only be used for industrial purposes. It cannot be used for consumption. Second, that same ENA can now be used for processing into potable alcohol. Now, assuming that your lordships do not overrule synthetics on the question of what is intoxicating liquor, what synthetics said was that in order to be intoxicating, it must be for human consumption, because the word intoxicating indicates that it is for human consumption. That, my lord, my learned friend has argued in detail, should not be the correct interpretation because of the legal meaning given to the phrase intoxicating alcohol, intoxicating liquor, long prior to it, including Balsara, etc. So, my lord, by overruling Balsara, synthetics said that intoxicating liquor means for human consumption. If so, If so, my lord, entry 8 at the very least will protect the state's rights on all aspects as far as potable alcohol is concerned.
Yes.
Now,
You said that synthetics overruled Balsara by holding that intoxicating liquor covers liquor for human consumption.
right. If your lordship, my lord, does not accept my learned friend Mr. Dwivedi's argument, then that part of synthetics will continue to hold. That, my lord, is the springing point or starting point for the second set of arguments, my lord. The first set of arguments, my lord, is complete if your lordship accepts that intoxicating alcohol includes, intoxicating liquor includes all alcohol. Then you don't have to go into this second argument at all. But the second argument is also important because, my lord, the judgments so far have accepted that position and carried on after synthetics, naturally. Even under that, entry 8 would at least cover the entire process as far as potable alcohol is concerned.
Yes.
And, my lord, here there is a little footnote. Whether or not we look at the amended IDR Act, that would be the position. Before amendment, the schedule to the IDR Act said fermentation products, alcohol, and the second heading. Even here, if intoxicating liquor included only potable alcohol, even then it would not be industry, it would not be subject to 52. Potable alcohol.
Because if potable alcohol is covered by entry
8.
can't go to entry 20.
Can't go to entry 20. This has become even clearer after the amendment because the schedule now excludes potable alcohol categorically. But that was actually the position even before.
Post 2016, in any case, potable alcohol is out.
Because, my lord, it is no longer a notified product.
Right.
Now, we are left with, my lord, denatured spirit.
Yes.
Most of the process for manufacturing denatured spirit is common to the manufacture of potable alcohol. In fact, I'm not saying theoretically.
Yes.
Up to the stage of ENA, there is only one process.
Yes.
If the state imposes any regulations in the manufacture of ENA, it cannot make a distinction between the end product at that stage. At that stage, it is not known what is the end product.
Yes.
So, my Lord, Justice Jeevan Reddy in Bihar Industries said that at the point of removal is the appropriate point at which you have to look at the end use. Whatever goes for the manufacture of denatured spirit will remain in the control of the union, and whatever goes for production of potable alcohol will remain in the control of the state. But up to the point of ENA, whatever is done as far as potable alcohol is concerned will necessarily also happen as far as denatured spirit.
Because it is after the ENA stage that the denaturing is added.
That's
the bifurcation.
That's it. The bifurcation takes place after that. So we let's suppose, and I give your lordship a concrete example.
What is the sequitur, Mr.?
Just one concrete example. Several states, my lord, have certain restrictions on the input-output ratio of molasses to the final product ENA. If it is within the efficiency factor, then there is no measure. If it is outside, it becomes subject to penalty. Now, my lord, if the state imposes a efficiency factor in the process of manufacturing ENA, at that stage, it will get imposed both on the quantity which will ultimately be used for rectified spirit as well as the quantity which will ultimately be used for potable alcohol. So therefore, my lord, keeping that reality in mind, my lord, we have to proceed to the next stage to see where the control of the state should end and where the control of the union should start. Up to that point, it becomes impossible to make that distinction, because whatever I do for potable alcohol will necessarily also apply to the manufacturing process for ENA, which is ultimately used for denatured. Therefore, my lord, now let us look at the legal analysis. My lord, this is a practical difficulty. Now let us look, my lord, at the legal analysis.
What happens after the process after the denaturant is added?
Yes. After denature, the product has already come into being. So there, my lord, the the denatured spirit is actually in that second stage. Production and manufacture has been completed now of that product. After that comes the question of distribution, which will go into NT 33. Why? Because denatured spirit is certainly excluded by the schedule of IDR Act. So, my lord, the notified product, if I may put it that way, the notified product is the denatured spirit. Now, if I apply, my lord, Tikaram, the raw materials used for the notified product, denatured spirit, ENA, is within the state's power. The distribution of the product is within the state's power. And, my lord, it is very important for the reason, my lord, that even denatured spirit, as a matter of fact, can re-enter, my lord, or try to re-enter the potable zone and create havoc. So, my lord, if the state has no power to regulate what happens at the distribution stage, then, my lord, there can be havoc. What is ultimately causing all these huge tragedies is where denatured spirit diluted with water, mixed up with some genuine spirit like whiskey, cheap whiskey, is then sold, and that creates havoc. It can become. No, even ethyl alcohol. That's right. That is, you're saying that because it is in order to make it denatured. Yes. My learned friend is saying that in order to make it denatured, you make it methylated, you add methylated spirit, then it becomes denatured. It should not be used for human consumption anymore. But my lord, in the market, it sometimes comes back, and by mixing it with some cheap whiskey, it is sold. So, my lord, the distribution is also a very, very important stage, not only for my lord revenue purposes here, my lord. My lord, here, my lord, entry 6 becomes absolutely important because public health is a state subject. Entry 6 of list. So, my lord, both under entry 6 and entry 8, it becomes necessary for the state to control the entire process of potable alcohol, which sometimes goes across to the question of to the control of the denatured spirit process as well. That's the factual background. Now, therefore, if I'm to analyze it now in terms of Tikaram, we'll put it into these 3 components, and only the middle component will be subject to union control, and the other 2 will either be state control, because, my lord, it is state control because of 26 and 27. Now the question is that if the product itself has become included in the schedule, ENA, suppose ENA becomes included in the schedule, then of course it will go to 33.
Right.
So far, my lord, the only thing in entry 33 will be denatured. That's the product which has been put there.
Yes.
Now, my lord, the simple point is, if you do not take into account Tikaramji's analysis, then you cannot reach the correct result. And Tikaramji has not been taken into consideration in synthetics. And my lord, the reason, my lord, I'm sure, is as Mr. Datar said, it was actually a matter relating to, my lord, tax. It all started with some provision of tax which was under challenge. It could have been decided on a much simpler basis, perhaps, but 7-judge bench, so it went into all issues which were argued. Now, one more thing, my lord, one passage from Bihar Industries, my lord. Give me your page. Volume 5, page 72. 5D, page 72. 5A. 5A, page 72. Oh, because it was in the previous compilation. Not in my compilation, it is already there. Bihar Distillery. Bihar Distillery, my lord.
5A 72 is VAM Organics.
76.
76, my lord. PDF page 76?
Yes, Bihar Distillery is 76.
Actual page is 72. Here, my lord, let me just place 23. I won't take your lordship's time. Para 23. Wait. We are of the respectful and considered opinion. PDF page 91. We are of the respectful and considered opinion that the decision in synthetics did not deal with the aspects that have arisen for consideration herein, and that is mainly concerned with industrial alcohol, that is denatured rectified spirit. While holding that the rectified spirit is industrial alcohol, it recognized at the same time that it can be used for obtaining country liquor by diluting it or manufacturing IMFL. When the decision says that the rectified spirit with 95% alcohol content VV is toxic, what is meant is that if it is taken as it is harmful and injurious to health. By saying toxic, it does not mean that it cannot be utilized for potable purposes, either by diluting it or by blending it with other items. The undeniable fact is that rectified spirit is both industrial alcohol as well as a liquor which can be converted into country liquor just by adding water. It is also the basic substance from which IMFL is made. Denatured rectified spirit, of course, is wholly and exclusively industrial alcohol. This basic factual premise, which is not and cannot be denied by anyone before us, raises certain aspects for consideration herein which were not raised or considered in synthetics. Take a case where two industries A and B come forward with proposals to manufacture rectified spirit. A says that it proposes to manufacture rectified spirit and then denature it immediately and sell it as industrial alcohol, while B says that it will manufacture rectified spirit and utilize it entirely for obtaining country liquor and for manufacturing IMFL from out of it, or to supply it for to others for the said purpose. According to synthetics, next page, my lord, A is under exclusive control of the union, and only power of the state are those which are enumerated in para 86. Those, my lord, were the limited powers which was given to the state under that judgment. But what about B? The rectified spirit manufactured by it is avowedly meant only for potable purposes. Can it yet be called industrial alcohol? Can it still be said that the state concerned has no power or authority to control or regulate industry B, and that union alone will control and regulate it until the potable liquors are manufactured? The union is certainly not interested in or concerned with manufacture or process of manufacture of country liquor or IMFL. Does this situation not leave a large enough room for abuse and misuse of rectified spirit? It should be remembered that according to many states before us, bulk of the rectified spirit produced in their respective states is meant for and is utilized for obtaining or manufacturing potable liquors. Can it be said, even in such a situation, that the state should fold its hand and wait and watch till the potable stage is reached? Yet another and additional circumstance is this: it is not brought to our notice that any notified order has been issued under 18G of the IDR Act regulating the sale, disposal, or use of rectified spirit for the purpose of obtaining or manufacturing potable liquors, which means that by virtue of entry 33 of list 3, the states do have the power to legislate on this field. Field is not occupied by any law made by the union. And my lord, the next two sentences beyond that, my lord, the line of demarcation can and should be drawn at the stage of clearance and removal of the rectified spirit. Where the removal or clearance is for industrial purpose, the levy of duty of excise and all other controls shall be of the union. But where the removal clearance is for obtaining or manufacturing potable liquors, the levy of excise and all other controls will be of the state. This calls for joint control and supervision of the process, etc., etc. Now, my lord, I come to the next proposition.
Yes.
The next proposition is this, my lord, and this was actually highlighted in the questions which were referred in the Lalta Prasad order, and that was, my lord, with regard to 18G. The reason why it is being referred is, my lord, two things happen in synthetics. It was said that because it has gone into 52, the entire field is denuded, and so therefore 33 will not apply to give states any leeway. And secondly, that 18G is an indication that it has denuded the whole field. Now, my lord, a very simple, my lord, aspect to be taken into consideration is that 18G was in the statute books all along from 1953 or so, my lord. Now, even when Tikaramji was decided, it was there. Every time Tikaramji, my lord, has been upheld, it has been on the face of 18G. If so, my lord, how could raw materials go out? How could distribution, etc., go out if the whole field was denuded? So, my lord, what has happened is, if you do not look at Tikaramji's judgment, you will think that it is possible to hold that the field has been denuded. But if you look at Tikaramji and follow it through, then you cannot hold that the field has got denuded. Because, my lord, at least two aspects, my lord, are out. Now, my lord, we have given the list of all the judgments which has followed Tikaramji up to ITC. Well, I'm not, my lord, taking your lordship through those. There are just, my lord, two, there's only one more aspect, my lord, which I want to point out. And this is also, my lord, because of, my lord, specific difficulties which may arise later on. At this point of time, we are not discussing any specific statutes with relation to, my lord, this aspect. But, my lord, if your lordship holds, and to the extent that your lordship holds, that the state has the power to impose regulatory measures, it may take the form of matters other than regulatory fees. Moment we say fees, it becomes, my lord, a situation where you might be asked to show quid pro. Yes. Cost of regulation, my lord, must be shown to somehow have a correlation with the amount imposed. It may be a vague correlation or a loose correlation, but correlation has to be there. Whereas, my lord, in fact, regulatory measures may include, my lord, some kind of penalties to discourage a person from doing something. This is not something which is fees and therefore requiring quid pro. So, my lord, all that I'm saying is, my lord, that your lordships, if regulatory powers remain with the state government for whatever reason, my lord, then, my lord, such regulatory powers should not be restricted to regulatory fees.
Yes.
My lord, those are my submissions.
Thank you, Mr. Gupta. Mr. Giri?
Yes, my lord, licensing is a very important way of regulation. So that, my lord, also, and as your lordship has heard from Mr. Datta, the states, my lord, in fact, are my lord, the licensing authority for all industries, my lord, which are manufacturing ENA today.
Wait, please. I beg to appear in civil appeal number 6708 of 2014. I think that is 901.14. 14 and 117, let's see, on behalf of the state of Kerala. Lord, the impugned judgments were passed on the basis of synthetics and chemicals without getting into any other issue. That's why, my lord, when the appeal was filed, the appeal was admitted and, my lord, tagged along with the matters which are already referred. My lords, my lord, in my written submissions are contained in volume 1D, D for Delhi. There's one other point, my lord, which arises from a judgment of Constitution Bench of this Honorable Court, which has not been referred to, but which arose from the same enactment, my lord, that has been considered. I'll take your lordships to that in a moment, my lord. See, I've given, my lord, the citation to the court master so that it is not part of the compilation of judgments, but I think it has been uploaded. Let's see. But permit me, my lord, to make a basis for what I wanted to submit before your lordships. My lord, if your lordships were to consider that an industry which is engaged in the manufacture of alcohol per se, without coming to the distinction of whether it is potable alcohol, industrial alcohol, or, my lords, the industrial alcohol in the sense that it is unfit for human consumption, then, my lords, your lordships may construe 24, entry 24 of list 2. My respectful submission is that it would not take in, my lord, an industry which is regulated, my lord, by entry 8. my lord, of list 2. And intoxicating liquors, my lord, which is the prime question that your lordships have formulated for consideration, as falling under entry 8. Whether it would take in all, my lord, subsects of alcohol, except denatured spirit, my lord, which has to go out of, my lord, the purview of alcohol fit for human consumption, or which could be made fit, my lord, for, because then it would, according to me, my lord, it would not be an intoxicating liquor per se. Denatured spirit can never be treated as intoxicating liquor per se.
So you're arguing something at variance with what?
Yes, according to me, intoxicating liquor cannot take in denatured spirit per se. Lord. This is what I have tried to say, my lord, in my written submissions also. Except denatured spirit, which is a matter of manufacture. All other aspects of all other varieties of liquor would come under entry 8. Every activity which would be comprehended by an industry relating to any product is textually, my lord, covered by entry 8 insofar as intoxicating liquors are concerned. Production, manufacture, possession, transport, purchase, every aspect of. Therefore, my lord, entry 24 will have to exclude, my lord, intoxicating liquors. Entry 24 of list 2. My lord, 2 hypotheses will not flow in my respectful submission. Going by 246, Article 246, and the general principles, my lord, which your lordships have laid down in innumerable decisions as to how to construe an entry in a list. My lord, the scope and ambit of entry 52 of list 1 will have to necessarily exclude any item, my lord, which is comprehensively covered by an entry, my lord, in list 2. And here, my lord, 24 would go out of the picture.
Now, what happens to denatured spirit then?
Denatured spirit, my lord, requires a manufacture of a specific commodity which does not become the raw material, my lord, for any other alcohol. My lord, there is no question of
Therefore, according to denatured spirit will be governed by IDRA?
Yes.
52.
Yes. The sequitur, my lord, is therefore, except denatured spirit, every other sect of alcohol, whether it is a final product or an intermediate product, would be covered, my lord, by entry 8. Let alone the question of levy of excise duty under entry 51. In fact, my lord, entry 51 of list 2 is treated to be complementary, and that's what your lordships have held in the judgment, to entry 84 of list 1. Because 84 of list 1, my lord, as it stood prior to the 101st amendment, specifically excluded it. And 51 specifically provides for it.
Spirit can come both under entry 24 list 2 and entry 33, list 3.
No, my lords, the entry 34 list 2,
24.
entry 24.
Because if it is, if denatured spirit is not part of intoxicating liquor according to you under entry 8,
Yes.
then the sequitur will be that, denatured spirit is governed by the schedule to the IDRA.
If it comes under entry 24, then it becomes subject to 52.
Yes.
Right. So in which case it becomes part of item 26. If it does,
Yes, yes, yes.
right?
Yes, yes.
If it does, it's directly governed by entry 33 of list 3. It's
Yes.
a product of an industry,
Yes,
the control of which is declared by Parliament to be
Yes.
in the
Yes.
public interest.
yes,
In which case it would still be within the state's regulatory power until Parliament were to enact a law to the
Yes.
contrary.
yes, yes. Until Parliament were to enact a law, my lord, in terms of,
ET&G also requires a notified order.
it requires a notified order. There's no
So
notified order.
The little nuance which you are putting, I mean, not a little nuance, but the difference from what everybody else has argued is that according to you, denatured spirit is out of entry.
Completely.
But are you therefore arguing that Balsara is wrong?
My lord, Balsara really did not consider the distinction. My lord, Balsara went into the question of why are the provisions, my lord, which provided a restriction on the import of not rectified spirit, not denatured spirit, but liquor as such. And therefore, there was no occasion in Balsara, my lord, to consider the distinction.
That was
Not only that, my lord, prior to the constitution, all those local enactments, my lord, which Mr. Dwivedi has provided in his chart, all of them, my lord, also define, my lord, spirits as including denatured spirit, and the entirety of control of anything to do with alcohol, including denatured spirit, subject to correction, my lord, came within the province of the provincial legislature. It is only, my lord, when it came, only when it came under the constitution. Sorry.
Even if we therefore really speaking, Mr. Giri, you are really in that sense arguing the second point, which
Yes,
is the
Alternative submission.
alternate.
Yes.
But the alternate submission which he argued is your main submission, in the sense that you are saying that there is no substance in their first submission. Therefore, the alternate submission is your main argument.
I'm saying that, I'm not trying to take away anything from what they have argued.
Not at all.
That is something which your lordships will have to
Right,
consider.
right. But for denatured spirit,
Yes.
your argument is directly contrary to what the others have argued before.
In the sense, my lord, but it is not, my lord, in antagonism to that. It is not in antagonism to
No,
that.
but you are saying that denatured spirit does not fall within entry 8.
That's correct. Not only a denatured spirit.
Only thing.
I'm saying, my lord, are distinct from 95% ENA, which is what is considered, my lord, in synthetics and chemicals. In fact, my lord, synthetics and chemicals need not have gone into the question of ENA or any other aspect, because the persons who had filed a petition were, my lord, distillers or were manufacturers of denatured spirit. And it was one, my lord, it was apparently because a license was not granted or some fee was remitted, some fee was demanded, that they had approached the High Court also, even in the first instance in 91. But then, my lord, then the court, my lord, probably because, as Mr. Gupta put it, probably because it was argued before then, that the lordships probably felt it necessary to go into these aspects. But otherwise, denatured spirit, according to me, stands completely separately. It's manufactured, my lord, it's manufactured with a process that is unique to it. There is no question of extracting alcohol from denatured spirit thereafter. Nothing. There's no question of comeback. Denatured spirit by itself is a product that cannot be, my lord, used for, and according to me, it cannot therefore come under 8, because it's not an intoxicating liquor. One cannot, my lord, treat the word intoxicating as a surplusage. Intoxicating liquor means it must be fit for human consumption. A denatured spirit is not. Lord, why I beg to, my lord, try to bring it under this entry 8 is because then I don't have to fall under 24. And 24 may not take in anything which falls under 8. And if I don't fall under 24, my lord, I'm really not concerned with 52.
think anything other than denatured spirit
Yes.
is something which is, we'll not say alcohol fit for human consumption, but alcohol for human consumption,
Alcohol for human consumption.
which has the potential for human
Yes, yes,
consumption.
yes, yes. My lord, there's
So
no,
you are appealing for the state of Kerala.
yes, yes. There's no rocket science,
So-
my lord, involved in
Right.
converting ENA, my lord, into, my lord, either
Denatured.
country liquor or anything, my lord, which is
You add
normally
the
consumed.
denature and that's all.
Nothing, my lord, just add water to it. And then, my lord, for the purpose of labeling it in different, my lord, very attractive bottles, you either add caramel, then it becomes rum, you add malt, then it becomes whiskey, and then the others, I don't know.
Mr. Giri, it's your theoretical analysis of the subject, we resume, therefore.
I'm saying I'll go by what Mr. Datar has provided in his chart. At page 12 of his written submissions, he has provided, this is how
You
it.
clarified by Mr. Datar has provided in his chart, not what Mr. Datar has provided.
No, my lord, I use the word chart.
So I think we've got the point. But therefore, you take it that you are paying for the state of Kerala, right?
Yes, my lord.
Therefore, you are not seeking to regulate or impose any regulatory fees on denatured.
No, yeah, we are not. Yeah. The issue, my lord, in the present case arises from, my lord, a demand for wastage fee on extra neutral alcohol.
So the wastage fee on it.
Yes. And that is how, my lord, it has come. No, my lords, there are 2 or 3 aspects, my lord, which may flow out of it, my lord. Can I proceed with it?
Yes.
No, my lord, insofar as the judgment in synthetics and chemicals are concerned, my lord, if Mr. Datar has taken your lordship's, my lord, to the take the judgment. Some of the paragraphs, my lord, which in his submissions, my lord, he said this, my lord, will have to be treated as not acceptable, and therefore, my lord, has urged your lordships to consider whether they have to be overruled. My lord, could your lordships kindly come back to synthetics and chemicals, my lord, because at the end of the day, your lordships are considering the correctness of the judgment. And this. Just yet.
question only. We will not go into the, the nitty-gritty of your particular
Yes.
provision, the wastage fee, as you said.
Yes. Sorry, is that, I'm sorry, but I didn't catch you.
No, I mean, we need not go into state-specific legislation here. We are.
No, we need not. We need not. This is only, my lord, this is an additional strength to the bow, if your lordships would kindly consider it that way. Without taking away anything, my lord, from the broad sweep of the argument which Mr. Dwivedi had made, that the alcohol which is mentioned in entry 8 would cover everything, every variety of alcohol.
Other than denatured spirit.
In my respectful submission, it cannot include denatured spirit, my lord, because entry 8, my lord, makes it intoxicating liquor. And my lord, there is one product which cannot be treated as intoxicating, my lord. Intoxicating would mean intoxicating for the human being, which means it must be consumed by the human beings. And it cannot be. There is no process by which a denatured spirit can be made into, my lord, consumable alcohol, as it were, or potable alcohol, as it were.
Correct.
And therefore, my lord, entry 8 will have to exclude that. Except that, if every other variety is therefore included in entry 8, my lord, the sequitur in my most respectful submission, forgive me for repeating, my lord, I don't have to concern myself with entry 24. And if I don't have to concern myself with an entry 24, then really speaking, my lord, I don't have to concern myself with 25 or 27. Because that is every aspect of it is, my lord, covered by entry 8. Because, my lord, I fall under entry 33, my lord, I have to take resort to entry 33 only when the parliament may by law, my lord, declare that any industry is one of public interest as such. Where therefore, my lord, the parliament cannot.
Therefore, when you say that therefore denatured spirit
Yes.
does not fall within the fold of entry 8.
Yes.
It necessarily therefore
Yes.
may fall under entry 24 and therefore under entry 52.
Yes. Yes.
But if it falls under entry 52,
yes,
then the state's regulatory power, even insofar as denatured spirit,
correct, my lord.
would be subsumed in, say, entry 33 of this
Correct.
3 then.
Correct, my lord, it could. But my lord, in my respectful submission, it is not necessary to get into that orbit at all, my lord. If your lordships are pleased to hold that the intoxicating liquor as contained in entry 8 would contain any other species of alcohol, as it were, except denatured spirit, because it can never become, my lord, manufacture is the ultimate stage, my lord, of a production. A production, therefore, my lord, would have intermediate stages. ENA, my lord, is one of the products which you get in the manufacture of, my lord, Indian-made foreign liquor. Molasses is another product. And from molasses, my lord, fermentation takes place. Extra neutral alcohol is obtained, which could be 95.5%. But that's alcohol, my lord, which would still fall within the ambit of
the state of Kerala's position, therefore, that the states will not have any role whatsoever to play in regard to denatured spirit.
No, my lord, in my respectful submission, if this argument, my lord, even otherwise, my lord, we don't do anything with denatured spirit. That's what I wanted to get myself clarified. We have nothing to do with denatured.
No, you may not be doing it, but ultimately, what is your submission
of states' powers?
About
states'
the power of the
powers, my
state?
lord, states' powers. For example, my lord, for setting up a manufacturing unit of denatured spirit per se, Lord, I don't think they have to. They have the power to issue a license, and therefore they don't have the power to regulate.
No, but licensing, as
Yes.
you are told, is for the alcohol manufacturing,
Yes.
right? At the stage when license is issued, it is not issued for industry A, industry B, two categories. It is issued, then the end product will determine whose control it will be.
There, my lord, there is.
Therefore, at the
No.
time of issuing license, that's what
Yes,
we are given
yes.
to understand.
Yes, my lord. Suppose it is for manufacture of extra neutral alcohol per se, then obviously the state would have the power. But the question as to whether it gets into denatured spirit or not comes about at the stage of clearance.
Yeah, that's right. So at the
That's
time
insofar
of-
as a taxing power is
At the
concerned.
time of issuing license, the distinction is not there.
My lord, they'll have to say what they are going to manufacture.
No, also an example was given. Let us say at a given point of time, an industry license it has,
Your lordships are right.
it is manufacturing. And there is a,
I
say,
stand corrected. Your
prohibition
lordships are
is
right. Your
imposed,
lordships are right.
say Bihar.
Yes.
Then what happens? He has a licensing, he has a factory, But that demand for the product is not there. For the
Portable alcohol.
portable, which gives a kick,
Yes.
no demand for that. Then
No, my lord. He has a license for manufacturing. He has a license for producing extra neutral alcohol. But does he have the license, my lord, to produce denatured spirit?
denatured spirit is at the stage of removal.
No, denatured spirit is also a
There is
product of.
also a levy, we are told, or at the stage of denaturing, you are imposing a fee that now you are putting denatured elements.
That's only they say that that's at the stage of clearance. Therefore, when it gets into the stage of manufacture of denatured
Up
spirit,
till the factory gate,
Yeah.
up till the factory gate, it remains in the purview of the state.
in which case, my lord, in which case, insofar as regulatory control is concerned, if it falls outside entry 8, it could still fall, my lord, under 24. In which case it will be subject to, my lord, to entry 33, 52 and entry 33. My lord, I really don't have to go to that extent, my lord, insofar as all other varieties of liquor except denatured spirit is concerned. It's only for that purpose that I see. But what fell from your lordships that the fact that it doesn't fall under entry 8 does not completely take it out of the purview of list 2. Your lordships are right. It could then fall under entry 24. You say it's an industry. If it falls under entry 24, my lord, it is then subject to entry 52 of list 1. If it is subject to entry 52 of list 1, then it is subject to entry 33 of list 3. In which case, my lord, possession, transport, and all those things, my lord, could come under the regulatory control of the state as well. I'm saying, my lord, I'm taking it from the point of view of exclusion, my lord. Except denatured spirit, all other varieties of alcohol would come under, and we are really concerned with intoxicating liquor fit for human consumption in this. For human consumption. My lord, my attempt is only this. Bring it under entry 8, then I don't have to come and I don't have to bother with entry 24. If I don't have to bother with entry 24, then I'm not bothered with entry 51 also. And then, my lord, entry 33 of list 52 also. Then I don't have to bother with entry 33, my lord, of list 3. For all varieties of alcohol, which would come under the broad category of intoxicating liquor, under which rectified spirit will never, I'm sorry, my lord, denatured alcohol will never come. The other sequitur, the other consequential question, would your lordship then say denatured spirit is completely taken out of the purview of list 2? No. The lordships are right. Lordships are. But I really don't have to labor on that, because in my respectful submission, my regulatory control is on the question of, my lord, the potable or intoxicating liquor, which is fit for human consumption.
That's all, Mr. Giri?
No, my lord, I need another 15 minutes.
All right, 15 minutes, and then now we're only left with Mr. Shradan Farah, sir.
Mr. Balbir Singh was in.
10 minutes, 15 minutes, and then
Not more than 20 minutes.
But Mr. Giri, you are sitting here from yesterday. So arguments of Mr. Dwivedi did not have intoxicating effect on you. You are having something contrary to that.
I don't know, sir, Lord. They have the potential. They have the potential of doing it.
So, Mr. Giri, you are suggesting that entry 8 gets kicked in only when the liquid has the potential to give a kick.
Give a kick.
That's wonderful.
Look, that's another facet of constitutional interpretation.
Actually put
Great.